Four is not enough. I would like to think so. All right, we are going to get started. Vashawn, yesterday I was saying all day it was Thursday and it was not. That was wishful thinking. I was hoping it was pre-Friday.
It was the Monday's Wednesday ever.
Yes. But you know, when I was at home with mom, I ended up having an allergic reaction. So I don't know if it's from strawberries or tomatoes. I'm hoping it's not tomatoes because I love tomatoes. But of course, you know what my mom says? I hope nothing happens to your hair. I'm like, Mom, my hair will be fine. Because my grandmother would always say, your hair is your crowning glory. Don't let anything happen to it. I'm like, okay.
Excuse me, members?
Yeah. Oh, hey, your hair looks beautiful. The only thing that's happening to my hair today is a lot of humidity. All right. So today is Thursday. Hello, welcome back. I'm glad we didn't scare you off.
You mind if I sit?
Oh, no, please have a seat. All right. So as everyone knows, he's trying to make a decision. He's an undergrad, correct? Yes, he's an undergrad. So he's trying to make a decision on whether or not he is going to. Just 1 second. All right. I'm sorry, you all. You know, when mom calls, you got to answer. Okay, Mom. You know, that's my mom. And you know why she was calling? She's like, is your allergic reaction done? And I'm like, yeah, it's gone. But it was right on my cheek. All right, so everyone, this is the intern. So attorneys, please share advice with him and let him know what you do and let him know whether or not you like it and what's the best thing about your job and the worst thing about your job. When I teach at UTSA and have people come, I always have them tell the students, what's the worst thing about your job? What's the best thing about your job? So they can really know if this is an occupation they want to go into before they end up with the equivalent of a mortgage for loans. All right, everyone, I'm going to call the docket. Please let me know that you are here. If you don't answer, then I'm going to assume you're not here and a warrant may be issued for your arrest. In custody, we have Kent Sturgis, Jose Coronado, Atlano Carrillo, Stephen Salinas, Blas Casimiro, Rafael Anthony Soto. Rafael Anthony Soto. Antonio Casablanca. Thank you. Thank you. Candace Cox. Candace Cox. In custody, we have Patrick Sanchez, Jose Sanchez, Dominique Nicholson, Wilbert Villamil, Jose Romero, Wesley James Crawford, Michael Herrera, Mario Pineda. Mario Pineda.
Your Honor, they're present on Zoom.
Okay, just give me a moment. Gracie Segunda. Okay. Leslie Cox. Leslie Cox. Jess Moffness. Jess Anthony Frank Mosnes. Anthony Fuentes.
Andy?
Yeah, thank you, Andy. Javier Esparza.
Here.
In custody, we have Sebastian De La Rosa, Damon Thomas, Tevin Towns. Good morning. Edward Castillo Bringas, Paul Cochran, Michael Mora. In custody, we have Adis Hernandez Rivas, Marco Marino, Orlando Cuevas, Rodolfo, how do you pronounce that last name? Aceves. Thank you. Jason Wilson. Arthur Beecham. In custody, we have Hector Lopez, Eric Gonzalez Lopez, Randy Lopez Benitez, Fraulein Guzman, Christopher Gonzalez.
There you go.
In custody, we have Chris Lynn, Elysia Sierra, Jonathan Nicholas. Gas-
You have a plea on that case, Judge.
All right, thank you. Gaspar Rodriguez, Michael Johnston, Jose Soto, Lazaro Estrada, Juan Soto, Lazaro Espinoza, Fernando Espinoza, Jeremiah Escato.
You'll show up right when I get back to the office.
Well, actually, yeah, probably will, but we'll take that up.
I'll be back before I go back to the office.
All right, thank you. All right, is there anyone whose name was not called or you came in late? Yes, what's your name? Anyone else? All right, and sir, you need to remove your cap. All right, anyone else? These are the rules of the court. Do not approach the clerk asking for a reset or continuance. I'm the only person who can give that to you. The criminal trial division files are in this box. Over here is family violence. Do not approach the court if you have not conferred with the state and have not conferred with your client. If your client is in custody, yes, they need to be brought out. Do not request your client who is in custody and then leave. Because of security reasons, the deputies are only allowed to bring out so many inmates. And if you ask for your client to be brought out and he's brought out and you're not here, in the words of my mom, you're being selfish, because that means another attorney cannot have their client brought out. And Campbell, I'm just looking at you because you're in my line of sight, but you haven't done that.
Oh, I've been asked.
He's done it.
Yesterday, it was Sharon Thorne. I just kept looking at her. I'm like, Sharon, it's not you. If your client is more comfortable speaking in another language, when we call an interpreter, do not leave, because we have a limited number of interpreters and they're only here for 5 minutes or so. Then they have to go to another courtroom. Does everybody understand the rules? The other thing, when we are on the record, please, if you are in the box, do not talk behind the court reporter. How do you know we're on the record? Because I will call the style of the case. All you have to do if you're talking to the court, if you're talking to your client when I call the case, just ask the deputies to have your client move to that end. They're very accommodating with that. Number one, the other thing, Vashon, can you raise your hand? Please do not congregate with your back to Vashon, because if she's sitting down and your back is to her, guess what she's looking at? I'm trying to get her some doors so that can be a true office for her. And please do not go over there and move her papers around and rearrange things to make it more comfortable for yourself, because that's considered her office in the courtroom. Just think about it if somebody were to come to your office and move things around. And she's going to let me know what attorneys do that. And if attorneys do that, I'm going to make it my business to come to your office. I'm just going to walk in and start rearranging things on your desk and sitting on your desk. And I'm going to bring her with me. We may have lunch in your office. So Today is Thursday, or as we call it here, pre-Friday. Let's be nice to each other. Let's be kind and considerate. Everyone, please confer. Thank you. Oh, and can you do me a favor? There are cases, this attorney, he says two of his clients are by Zoom today. But, they just showed in. Okay, all right, got it. Thank you. Yes, yes, they zoomed in.
Well, I need to let you know what happened.
Where's your client?
Mental health hospital.
Okay,
You didn't call her, but it's on my doctor.
okay, sure. All right, Mario and Grace Segunda, I'm going to put you in the waiting room. As soon as we're ready for you, I'll bring you back into the main room.
What did I do now?
No, you were in my line of vision. Usually it would be me looking at Robert.
Oh, well, yeah, but why would you if I'm here? All right. I guess we'll set up. Good to see you, Doug. Hi, Doug. Hi, Robert.
And Robert, have you spoken to the intern?
Hello.
Yes.
Robert, how are you doing?
Yes. Robert's son was just licensed.
Yeah, he works for me now.
Mm.
You go see.
Yeah. That is so true.
Oh, yes.
Yeah, he was at live shows. He did that live stuff.
Yeah, he did for a bit, now he's doing.
Okay. Nice to meet you. Hey, Karen.
What's your last name?
Karen?
Yeah. He was part of the.
No, it's the guy who's spending this.
No, I'm good friends with Oscar Kazin and.
Oh, okay.
Yeah.
Oh, yes, if you can give it to them. Thank you. All right, and if you have any questions about anything, just let me know, okay? Oh, yes. The clerks and I'm gonna work with you and I will let you see what the clerks do because sometimes they need help with the files and everything. Okay, awesome.
Antonio Casablanca is an MTR.
I do have it.
He applied to Veterans Treatment Court. But they just got his DD 214 and his application letter yesterday. So I was gonna see if we recall him for next Thursday.
All right, probation. All right, I do see on July 6th that there was on this Casablanca thing, it was for him to be interviewed for VTC.
Right, so the VTC, Mr. Herman just texted me this morning indicating that he just received the DD 214. The documentation he was given before was not adequate, so he just received the DD 214. He said it's gonna take about a week to a week and a half to get him screened.
All right, so we'll know by a week and a half.
Yes.
Okay, let me look at the calendar.
Not the 20th, but if we're not gonna do anything, if we can come maybe the 18th or 19th, just so we can make sure he's been approved.
Okay. All right, where's Mr. Casablanca?
Antonio.
All right, so you're okay for July 19th?
Yes, ma'am.
All right. Caroline. Oh, did she step out?
You wanna?
Oh, hi. Caroline, could you put July 19th reset form for him? All right, so we'll be back on July 19th. Just sign the reset form.
Well, then, all right, thank you.
I'll let Mr. Herman know.
All right, thank you.
Castro, Alexander? Okay, thank you. Yes.
Was he here already?
Not yet. We had to think about the rule.
This is Caroline. Good morning, Caroline.
Thank you, ma'am.
Oh, this is one.
You just want to be here, right?
We just. No. So I don't know if you can see that.
Well, let me see, he's gotta be. I'm gonna go get this. Be back. Thank you. The water.
Carolyn, that's coming in printer. That's for me.
So.
Yes.
Wait.
Okay.
Morning, Your Honor.
Good morning.
Good to see you.
Good to see you too. And of course, Miguel, I have another intern. So Miguel has also been a prosecutor in Puerto Rico. All right, the person who's here on Caballero. My understanding, your client is going to be by Zoom? All right, I'm just waiting for them to zoom in.
We're gonna find out if there should be.
Yeah. Is this file or the one?
Here, this is your first file.
They're telling you our work.
Yeah. I can't read. I think they may have to. Caroline, I could tell you that. Caroline, could you- You could tell you.
So there we go. I think.
Yeah, but one of them is from a place I've never.
Sam's house.
Yeah.
I heard of people doing names. Yes.
Yes. How you doing? Good to see you too. So how are you enjoying this? Yeah. Mhm. Yeah. Yeah. I always tell everybody, I enjoyed the freedom of it. So. Mhm. Yes, you are. And you get to make whatever decisions you want to make. And it's nice not having a employer. Yeah. Mhm. They don't do the criminal. That's awesome. Which firm are you with? Oh, that was awesome. That's awesome. Oh, well, you're going to be starting the new division then, the criminal law division. That's always nice. Oh my gosh, that looks so beautiful. Oh, wow. Well, you know, I don't swim.
I don't have a problem with that.
Yeah, I don't swim though, but the water looks beautiful. I tip my toe in and pull it out. And then, okay. See, if something happens to me, and my mom is gonna say, what were you doing in the water when you know you can't swim? I'm gonna say, Miguel. Miguel? Yeah. Yeah. Oh, wow. Mhm. Yes. Oh, wow. See, I still haven't had a chance to go to Puerto Rico yet.
You're in the first row.
Okay, that is on my list to do. You too.
Yeah.
I understand. Me personally. Yeah. I'm not.
Right, guys. Lastly, I don't know how to say it, just so. I say lesson. Oh.
All right, so these are documents where the bondsman is requesting to surrender surety or get off someone's bond. And usually the bondsmans will issue that when a defendant is not abiding by their rules. So the court has rules, but the bondsman has their rules for their contract. So that's completely separate from the court. But sometimes bondsmen will say, you have to call in once a week, or you need to come into the office once a week. And when defendants don't do that, then the bondsman will want to get off their bond because they think that means that they're not going to show up for court. So let's say someone has a bond that's $100,000. If their bond is set at $100,000, some bondsmen will say, all right, give me 10% or 5% or 3% of that, and I'll get on your bond. And so they're able to use that to have the person get out of jail. And if a bondsman is making a bond for $100,000, they have to have some sort of collateral to back that up. So you just can't write a bond for $100,000 and you don't have a property that's worth that much or something to show that you'll be able to make that bond. So, yes. No, not to the court. There's a whole section in the code about what the bondsman must abide by. So you just have to have a record for it. For example, if a bondsman were to make $100,000 bond, they wouldn't come to me and say, here's my property that shows I have 100,000. That's a completely separate division. All right. So when a bondsman makes somebody's bond, I'm assuming they have that because someone else is in charge of that. So let's say the bondsman makes $100,000 bond for somebody and they charge them $5,000. They pay the $5,000. If that person's supposed to be in court and that person doesn't show, and the bondsman doesn't file an affidavit to surrender or get off their surety, you know, what ends up happening is I will issue maybe a bond forfeiture because they didn't show. And usually when bond forfeitures are issued, that means that the bondsman usually has about a week to get their client in and ask the judge, maybe, hey, here he is now, can you recall it? Because even though that person may have paid the bondsman $5,000 or $10,000, if the bond is forfeited, that bondsman is on the hook for the full $100,000. We once had when I was a defense attorney, there was an attorney who made $1 million bond for his client. When I first started practicing, attorneys didn't do bonds really. You either were going to be an attorney or you're going to be the bondsman. And so this attorney made $1 million bond for a client. And it was all over the courthouse because courthouse is like high school, that the attorney was on the hook for $1 million. And his client left and went to Mexico. And he had to find him and get him back here. Otherwise, he was going to be on the hook for $1 million. Yes. Yes. And bondsman, being a bondsman, it's sort of like gambling a little bit because you're hoping, hey, my client, you know, the person I'm a bondsman for, they just paid me $5,000. Ooh, great. I got $5,000. Hopefully that person shows up to court, because if that person doesn't show up to court, we may be on the hook for $50,000. So it's gambling in the sense that you're hoping that that person is going to show up on time. Now, sometimes some bondsmen will have people as a collateral. They want their client to put up some property for collateral. So sometimes it's a car, you turn over the title. Sometimes it's a home. When I was a defense attorney, I would always tell parents, look, don't sign over your home. Because if he doesn't show, this bondsman is going to take your house. And there's going to be a lien on your house, so don't do that. But that would happen a lot. So. Well, I've never had a chance to see it through to the end, but there have been times where there's a lien on the house. So that means if you're trying to sell it, you can't sell it because this person is owed $100,000 or whatever amount it is. So that's what usually happens. And usually what ends up happening, people who work for bondsmen, they will actually go to every court to make sure that client showed up. Like, for example, somebody just came in here to see if a particular person showed up because they're on the bond. Yes. And they will check with the docket and listen to me call the docket and then see if that person answers or not. And if they don't answer, now it's where's my client? So that person is saying, I'm going to go get him and get him in here. And usually I give people till about 10:30 or so. For example, the one attorney who says, I'll come back and not leave the court to go to my office until I stop back here. So his client was supposed to be here yesterday and he wasn't here. And it's a state jail felony. So I gave him a chance. We're just going to come back today. And his client is still not here. So he's going to see if he can get in touch with him. And his client, the clerks will let me know if they're on a PR bond or if they are on a commercial bond. So. Oh, no. I only let people zoom in. For example, the people who are zooming in now, I'm allowing them to zoom in because their case is not set for trial today and they're in Houston. When people are out of state or out of town, unless we're in jury trial and you need to be here for a jury trial, I'll allow them to appear by Zoom because to me, it makes no sense to make somebody get in a car, burn up gas, come down here for a reset and you're coming out of county. Now, if you live in Bexar County or surrounding county, you need to be here because this is court. But I do make allowances for attorneys' clients who are out of state or out of San Antonio, and sometimes for defense attorneys who are not in state, because sometimes there may be trying a case in another county as well. Yes. 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 So this person here, he doesn't have a court date yet. So the bondsman, because they haven't been in contact, he hasn't been in contact with the bonds, and the bondsman's like, he's not going to show, let me not be on the hook for whatever amount this is. And the other thing they have to do when they want to get off the bond, if the person has an attorney, they have to notify the attorney. So you can notify the attorney by email or fax. So.
Good morning. I'm me, the judge.
All right, who's here? And Gracie Segundo and Mario Pineda.
Your Honor, I'm here on behalf of Javier Oliva, or with Javier Oliva, rather. I believe he's the attorney on record.
Yes, he is.
Judge.
No, they're in Houston. All right. So where are we with the medical records?
So those should have been dropped off at the court floor. I can double check. I think they had to get redacted, so it was just going through everything.
All right, so has that been done?
We received some of them, and then they were uploaded, and then I think they were taken back so that they could be redacted, some of them.
And I could do that right away, Judge. Sorry.
Okay. No problem. All right, Norma.
And Judge, I think one more thing. We just need about a week really to make sure that we can get in contact with two witnesses. They've been traveling, so we've never really been able to establish a place for them to zoom in and, go over things with us. But next week, apparently, they're going to be in a place for about a month. So they're going to be somewhere stationary where we're going to be able to actually get them on Zoom.
All right. So Ms. Ferguson, on these cases, set this for mid-August.
For another compliance hearing?
No, this is going to be state, you are going to have to confer off docket. So the state is going to give you an offer And this date that's coming up is going to be your plea deadline date.
Okay. Thank you, Judge. Your Honor, if I may, mid-August, Mr. Lee was traveling. He'll be out of town till like the 8th. I don't know if that's.
Oh, we put it on August 21st.
Oh, okay. Beautiful.
Yes, no problem.
Thank you.
Thank you, Judge.
They're gonna be on Zoom, Judge, or they're gonna be in person?
There, it's fine for them to be on Zoom for the plea deadline date.
Worst case, Judge, we can do the plea paperwork online. It's just gonna take a little bit more time for me to get it done.
Yes. All right.
If that ends up happening.
Y'all need to just let me know, because it takes a lot of time for me as well.
Okay. All right.
We'll
So,
know better.
all right. So we'll be back on August 21st. And your clients can appear by Zoom since they are in Houston.
Yes, Your Honor. Thank you.
Thank
All
you,
right.
Judge.
Thank you. Jordan, how's it going? Oh, we got some background noise.
To a motion
Yay.
video.
Yeah.
I might have approached briefly.
Sure, don't.
I have a plea on a possession of one case.
Mhm.
I just need to know the court's preference. I have prepared a motion to seal an exhibit.
Yes.
However, defense is willing to plead guilty and acknowledge it. So I don't know if you're okay with not offering the exhibit or do you
No,
want the exhibit?
that's fine with you not offering the
Okay,
exhibit since
perfect.
he's going to be pleading guilty. And I'm assuming that in the stipulations, it will have what is on the videos.
In terms of the specific acts.
Yes.
I don't know how specific it is, but I'll make sure it's specific enough.
All right. All right. Thank you.
All right. Maybe a small modification. to that. Cool.
And are you already on Caballero? Who's the attorney on Caballero? Oh, can you let him know when he comes back? His clients have not zoomed in. Yes. Right. And this is what's coming up on this case. All right. Who's here on Michael Mora?
Judge, I am Sam.
And where's Michael
Mr.
Mora?
Morris here.
Oh, come forward, please. Hello, Mr. Mora.
Oh.
All right, the first thing we're here on is a violation report. And so there's an issue. What do you think the issue is?
No problem.
Yes. So they are trying to help you, but they're saying that you're not showing up. Can't help you if you don't show up.
No, it's still reporting, because I got to report to like 4 different places.
Mhm.
At the same time, I enrolled in classes, I got the classes already enrolled. I'm just waiting for my time.
Ms. Ferguson,
Yes, ma'am.
can you see if you can have Angelica Sosa, the pretrial service officer, zoom in? And we're gonna figure out what's going on. Because are you in receipt of the violation report?
I am, Judge, but there's another issue.
What's the other issue?
So Judge, I did reach out because there was a note in our system to contact a specific investigator.
Mhm.
Apparently, the feds are going to get involved and are planning to have indicted the case back in May-June. I haven't double checked on that just to see what the status was, but they told us that they intended to indict him in like June 21st.
All right, well.
I don't believe he's indicted yet, or I think they'd be here to take him.
All right, this is what we're gonna do. We're just gonna deal with what I have in front of me. And the first thing for you is to make sure that you're clean and sober, because you're not gonna be any help to your attorney on the federal side or Ms. Kramer if you're not clean and sober and thinking clearly. So that's the first thing we're gonna do. So we're gonna call your pretrial service officer and see what is the issue with his reporting for the meth issues. Because they are sending me this violation report, and this is us having a conversation. It's not on the record. So we're having a conversation so I can see what we can do to help you with your issues or your addiction to meth. Okay? So she's gonna call her and have her zoom in. So if everyone will just be in a holding pattern as soon as she zooms in. And Ms. Kramer, if you don't have anywhere else to be, if you could wait a little bit.
I do, but if she zooms in really quickly, that'll be
Yes.
fine.
All right, thank you.
Thank you, Judge.
Yes. Yes. And so what ended up happening, that's a first degree felony. What ended up happening on that case is that the state, and when I say the state, the district attorney's office made an offer of pretrial diversion and he completed it. And now he wants his weapons back. And there are a lot of weapons. And so I had them leave to do research. And I did, of course, I did my own research as well to see whether or not he's entitled to the weapons back. And whether I think he should have his weapons back or not, the whole issue is whether or not legally I'm supposed to give them back. So that's where we are.
Oh. Okay. And if you can just.
Excuse me, what is your name? Is this your client? All right. Sir, you need to have a seat somewhere. Could I see that, please? All right, we're going to go on the record. Court is calling 2019 CR 10379, State of Texas versus Christopher Caballero. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Ruben Pisani for Mr. Caballero.
And are you Christopher Caballero? You need to unmute.
Okay, yes, ma'am. Christopher Caballero.
All right. And I'm going to place you on mute. Your client is appearing by Zoom. Any objection from the state?
No objection, Your Honor.
And defense, I'm assuming you have no objection.
No objection, Your Honor.
And Mr. Caballero, if you could unmute again, please.
Okay.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Christopher Ryan Caballero?
All right. Do you have any objections to appearing by Zoom?
No.
All right. And you understand that you do have the opportunity to appear in person in court?
Correct.
All right. Thank you. All right. We are here for a motion to return of seized property. And the property that the defendant is asking be returned is a loaded Springfield Armory XD 9mm handgun with 1 magazine and 12 live rounds. A Saiga SAIGA 7.69mm rifle with 1 magazine and 10 live rounds. And those are the weapons that you're asking to be returned, counsel?
Yes, Your Honor.
And you're not asking for the magazine to be returned, are you?
Not the live ammo, but the magazine and the weapon.
So you're not asking for any of the live rounds?
No, Your Honor.
All right, we previously had a hearing on this and I asked everyone to review any case law because I don't think your client should have these weapons back. But I know what the law is, and of course, I will always follow the law. I think it's odd that someone has a drug case and now he's concerned about some weapons. And I don't even think these weapons are antiques or some weapon that you can't find everywhere. Is it just the expense? Why does he want these weapons back?
Yes, Your Honor, just because he did purchase them legally under his name and they are his property. They're relatively valuable, probably around $2,500. So that's a substantial amount of money for him.
Your Honor, I believe, is there some case law you have?
Yes.
So I believe the defense has some case law that he cited in his motion I was unable to find any case law that says that to cite to bring before the court today. It is our policy to oppose these types of requests to get weapons back, Judge. And there was a version of the defense motion that requested the weapons be returned to defense counsel rather than the defendant himself. So we would request, if you were going to order the weapons be returned, that they would be returned to defense counsel rather than the defendant, Judge.
Do you want them returned to you?
Your Honor, if that's what the court wants, as long as the court allows for us to then return them to him.
No, I mean, it's just either yes or no. Do you want the weapons returned to you or do you want them returned to your client?
To my client, Your Honor.
All right, so the court has reviewed case law. And under Article 18.19 about seized weapons, if you all want to review it and look at it, it says, weapons seized in connection with an offense involving the use of a weapon or an offense under Penal Code, Chapter 46, shall be held by law enforcement agency making the seizure subject to the following provisions. Unless the weapon is a prohibited weapon identified in Penal Code, Chapter 46, and Chapter 46 has to do with all weapons offenses like unlawfully carrying, or the weapon is alleged to be stolen property. So the first question is, do you have any documentation that these weapons are his?
Your Honor, I did ask my client. He said that it may be possible for him to procure a statement like either bill of sale or receipt from when he purchased the weapons. But he did say he purchased them himself, so they should be under his name.
All right, so one, that's what the court is going to need to show that these are actually his weapons.
Sure.
All right. Now, the other thing, if there is no prosecution or conviction for an offense involving the seized weapon, the magistrate to whom the seizure was reported shall, before the 61st day after the date, the magistrate determines that there will be no prosecution or conviction, notify in writing the person found in possession of the weapon that the person is entitled to the weapon upon written request to the magistrate. So he's already requested it back. D, a person either convicted or receiving deferred adjudication under Chapter 46 is entitled to the weapon seized upon request to the court in which the person was convicted or placed on deferred adjudication. However, the court entering the judgment shall order the weapon destroyed or sold if the person does not request the weapons before the 61st day, which he has. The person has been previously convicted under Chapter 46. So I need to know whether or not he's been previously convicted under Chapter 46. The offense for which the person is convicted or receives deferred adjudication was committed in or on the premises of a playground, school, video, arcade facility, or youth center, as those terms are defined. So I don't know, because this is a pretrial diversion, I don't know where he had the weapons. Or the court determines based on the prior criminal history of the defendant or based on the circumstances surrounding the commission of the offense that possession of the seized weapon will pose a threat to the community or one or more individuals. Here's the issue. It has to be a conviction or receiving deferred adjudication. He wasn't convicted. He didn't receive deferred adjudication. So if he provides proof to the court that these are his weapons, either through a bill of sale or some other documentation that the court can view, I am obligated legally to return the weapons to him. Do I think the weapons should be returned to him? Absolutely not. Do I think it's odd that he received a pretrial diversion for a drug case and he's concerned about weapons? That should be the least of his concerns. But legally, I must return the weapons. So I will return the weapons once he provides proof to the court that these are actually his weapons and not someone else.
Sure.
So he needs to provide that. And once that's provided to the court, we can place it on the record that I received that and we'll go from there.
Yes, Your Honor.
And that's the case law or the statute that the court has seen. If, when he provides the bill of sale, if he can, if somebody finds some new case law or something new happens, you can always let the court know. we can go off the record, but as it seems here in Texas, they're even close to passing a law where people who violate protective orders, that they can have their weapons back. And I think we're going to get to the point where even if you have a domestic violence case, I think the government, the Texas legislature is looking at even giving them weapons back. So that's where we are.
Yes, ma'am.
So, and if you all would like, you can, the article is 1819.
Yes, ma'am.
And so counsel, as soon as you have that information, just come back to the court.
Absolutely.
Okay.
Thank you, Your Honor.
And I'll make sure that I look at it and review it. And if somebody has an issue where you think, oh, this is not the appropriate bill to sell, just let the court know.
Absolutely. And I'll provide it to you in advance.
All right.
Is my client excused?
Yes, your client is free to be excused. Thank you, Mr. Caballero.
Thank you very much. Have a good day.
You too.
Thank you, Judge.
Thank you. All right, Suzanne Kramer. Sosa is on. And Mr. Mora. Hello, Ms. Sosa.
Good morning.
Good morning. Thank you for popping in. I love pretrial service. You all just pop in when the bat signal goes out. This is Michael Mora. Were you able to pull up information on him?
Yes.
All right. So I received the violation report for testing positive for methamphetamine.
Yes.
Both the state's attorney and the defense have informed me that this may end up being a federal case, but
Okay.
I want to make sure that he's clean and sober. So he's informed me that he's already signed up for whatever he needs to sign up to help with his drug addiction. Has that happened or no?
I have not received any paperwork from him nor the counselor or whoever he went to get the assessment done. I know I sent him to either Cicada or Lifetime and told him to choose which one, but I have not received usually if it's Lifetime.
All right, everyone, please whisper. Yes.
If it was Lifetime will usually send me the assessment when it's complete. Or Cicada, usually the defendant would have to provide proof that they enrolled it to Cicada. But I have not received any documentation whether he's in class or not.
All right. So
Judge, if I may, he
Yes.
just told me that he did email, I don't know who, Miss Sosa, proof of enrollment.
all right, who are you enrolled with?
Wow. It's a class, it's for the Zoom class, it's a 1-day class. It's on the.
Oh, no,
12th.
you need more than one day.
And then I have an assessment with, what is it, outpatient? And on the 19th.
All right, what classes, that one class is not going to be enough for you.
That's the class that they told me that was on the paperwork. That's the class they told me to.
All right, which class is he talking about? That's one class.
The 1-day.
So he has to do the 1-day behavioral health orientation, but then
Okay.
Lifetime, the outpatient treatment, Lifetime recovery, it's usually a 30-day to 45-day program and it's 3 classes a week. So again, I don't know what he enrolled into because I have not received any documentation. I did receive an email from him this morning stating that he enrolled, but that was it.
All right, so you need more than an email.
I mean,
No. I mean, when I say more than an email, you just can't send them an email and say I enrolled. You've got to send them documentation. All right, so if you enroll with Lifetime, just sending them an email saying I enrolled in Lifetime, that's not good enough. You need to actually send them the documentation from Lifetime. So are you with Lifetime or not?
Yes.
All right, so this is what I'm going to do. Ms. Kramer, I'm going to give him 3 days. And he needs to provide proof to his pretrial services officer that he is enrolled with Lifetime Recovery. So let me see here. And I don't want you to throw up your hands just because you've heard that the federal government is going to be picking up cases. You still need to be clean and sober. Because the last thing you want to happen is you're using drugs, you get a bad batch, you end up ODing and your attorney hears about you on the news. Do you have any children? Who do you have in your life that's supporting you?
me and my girlfriend.
All right, so your girlfriend doesn't want to read about you being found somewhere, you understand? All right, so I'm going to give you. I'll give you till Wednesday. All right, so he needs to have this information to you by Wednesday. And that's July 12th. And if he doesn't give that documentation to you, just please send me another order. And if they send me another order, we're going to be on the record. You understand? All right, Ms. Kramer, is there anything else?
That's all, Judge. Thank you.
Ms. Souza, is there anything else that you need me to let him know?
No, just a reminder, the behavioral health on the 12th.
All right, so that's the 12th. You understand? Do you need that written down?
Please.
Okay, I'll get a reset form.
All right. Well, no, written down the fact that he needs to.
Oh, I'm gonna talk to him about what to do on that.
Yes, to give the information. And what I'll do.
kindly send an email if that'll help. I can send him an email.
Oh, awesome. She's going to send you an email. Is your same email working? And then what I'll do is I will have them in the back make a copy of this sheet for you, okay? Can you go in the back and have them make a copy? Yes.
Thank you, Judge. May we be excused?
Oh, as soon as she gets the copy.
But after we get that, yes.
Yes, and then wait a minute, we're not done yet.
Oh.
His cases, he needs a reset on that. So Norma, on this case, can you give me a reset for 45 days? Because that should give the federal government enough time to do what they're going to do. And after that, we're going to start the ball rolling on this case.
I think August 24th.
All right, we're going to do August 24th. Ms. Ferguson will give you the reset form for that. But remember with Ms. Sosa, you got to give her that information by July 12th. And she's going to send you an email and they're going to make a copy of that form for you in the back. Okay. All right. Is there anything else you need help with? All right. It's probably best for you to start doing NA or AA classes. They're all around the city and you can do one a day. Is your girlfriend using as well?
She's trying to get me off.
All right. Well, maybe she needs to go to classes for, what is it?
Al-Anon.
Yes. Okay. All right. Good
Okay.
luck.
Thank you, Judge.
All right.
Am I good to go, Judge?
Thank you so much. You're excused.
Thank you. Have a good day.
All right. You too. Hey, it's pre-Friday.
It is. It is. Friday Junior.
Yes.
Have a good one.
All right. You too. Thank you. And if you got to go give it to Suzanne Kramer. Thank you. All right, we're going to take up Leslie Cox and then we'll do Kent Sturgis. Leslie Cox.
Who's present, right, Judge?
Oh, wait a minute. This is Kimberly Burley's daughter. Hi. Judge Burley's daughter, I should say. All right, so where are we on this case? You have all the discovery?
I don't, Judge. There, it's the Live Oak PD case. I have that discovery. I have all the
okay.
discovery. So some videos were sent to the DA's office. Those are going to be uploaded today.
Mhm.
I'll need some time, of course, to get those, review those, et cetera. It's our first setting. We do have an offer. We have represented the court that we have received that part of the discovery.
Okay. All right, Ms. Ferguson. On Leslie Cox, can you give them a 30-day reset for discovery?
Sounds good.
All right, and Ms. Cox, you were late today. Why?
There was a wreck on the highway right here.
Was this the wreck they have on 90? You
Yes.
know, people, behind that wreck. So that's why I always tell people you need to leave early to anticipate this thing. And everybody thinks they're going to get $1 million, so nobody wants to move it to the shoulder. So everybody, accidents, move them to the shoulder. People can tell you were hit behind by your bumper. So, all right, so we'll see you then. You're welcome. Just sign the reset form, then you're excused. All right, who's here on Sturgis? All right, State, before we go on the record, have you had a chance to review the PSI report?
Yes, ma'am.
Okay. And defense, have you had a chance to review?
Yes, Your Honor.
All right, court is calling 2023 CR 3132, State of Texas versus Kent Mitchell Sturgis. Can our parties announce for the record for the state,
Hank Wilkins for the state, Your Honor.
for the
Sure.
defense?
Cheryl Patterson for the defense.
And are you Mr. Sturgis? All right, you entered a plea of no contest on May 22nd to the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams. According to the plea bargaining agreement, punishments be assessed at 7 years in the prison, and the state is silent on your application. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No,
All right, the state is silent. Defense, do you have any witnesses?
no, Your Honor. I would like to ask Mr. Sturgis a few questions, please.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Ken Sturgis.
All right, defense?
Mr. Sturgis, in the PSI, they are recommending some sort of treatment, inpatient or outpatient. Would it benefit you if you were to be allowed to go to drug court?
Yeah, no, I have a problem, so I like to do something. Outpatient, drug court would be great.
Okay.
All right, I'm sorry, you're gonna have to speak up so the court reporter can hear.
Do you have a place that you can live while you're going through this treatment?
Yes, ma'am, I do.
And it's here in San Antonio?
Yes, ma'am.
After you are finished with treatment and are successful with it, what are your plans after that?
If I could go up to Missouri and get to work, that's what I plan to do unless I can wait it all out here.
Do you have family in Missouri?
Yeah, I've got a strong support system.
Okay. Would you be willing, once you get up there, to continue some sort of treatment?
Yes, yeah, I can do that.
No further questions, Your Honor.
All right. States you're silent, but is there any questions you have for Mr. Sturgis related to any fact issue?
No, ma'am, no questions, Your Honor.
All right, everyone, just give me one moment. All right, so Mr. Sturgis, how long have you been using drugs?
A little while now.
What does that mean?
Since I was in my teens, off and on,
And what drugs have you been using?
meth.
Do you have children?
Yes, I do.
How many?
I've got 3 boys and a daughter,
What are their ages?
15, 12, and 10, and I got a 2-year-old girl
And who do they reside with?
with her mom.
Okay, same mother?
I've got 3 different baby moms.
You have 3 mothers of your children.
Yes,
We don't do baby mamas in this court, okay?
yes.
And where do they live as far as, are they in Texas or somewhere else?
Missouri and Florida.
Why are you in Texas?
My mom is down here. Can't be close to her.
And so you thought to bring trouble to your mom's doorstep?
I wasn't intentionally.
All right, so I want to know about your criminal history. There is a case in here that says you received 3 years for armed criminal action. What is that?
I used a weapon on some,
All right, what? Tell me about that.
I came home to another man with my old lady. And grabbed a hatchet and hit him with it,
Grabbed a hatchet and what?
hit him with it.
Well, I'm assuming he survived because it's not murder.
Yeah.
Well, did he survive?
Yeah,
Where did you hit him?
on the head.
And how did you get caught in that case?
I called the cops.
And so you did 3 years in prison for that?
Yes, ma'am.
Okay. And do you want drug treatment?
Yes, ma'am.
And that armed criminal action case, what state was that out of? Missouri?
Yes, ma'am.
I always like to look up new laws, so I see. Okay. Any other questions for your client?
No.
All right, I always review everything before sentencing. And I do see that during this offense, it appears that you were extremely high because it says that you were sweating and driving around with no clothes on. I'm going to give you a choice. Deputy Laura always says probation in this court is very hard. And the reason why it's designed so is because I want people to be rehabilitated. And I don't do cookie cutter probation for people. It's each person I see before me is an individual. I don't see people as criminals. They're human beings who've done some bad things. So they're asking that your punishment be assessed at a cap of 7 years. If you would like, I will give you probation. Or I can sentence you to 4 years in the prison.
I'd take probation if I could.
Okay. All right, then this is what the court will do. I'm going to sentence you to 7 years in the prison. It will be suspended and probated for 8 years. There is a $1,500 fine that will be probated. 300 hours of community service restitution. I'm going to require parenting classes and probation. If you can see which parenting class would probably fit best for him. So if you think compadre, Ramos, whichever one. There's to be regular reporting by Zoom or in person. He's going to do the UA hotline upon release until further notice. We'll do a referral to felony drug court, and that's in custody. If he's not accepted, then we're going to follow the recommendations from the TAP evaluation, and they are saying SATIF.
Yeah, sure.
Okay, so if not accepted, then follow TAP recommendations. If you were released, who would you be staying with?
Miss Gay and Church, Texas.
Oh, you're gonna be here. How far is Church from here?
It's just.
Thank
it's
you.
like
You know, I don't know. I haven't learned, even though I've been here for a while, I haven't learned all the areas in Texas yet. It's close.
Yes.
Okay. But Sean, you know, when I first came to Texas and I was trying to find St. Mary's University, my mom was driving. And it was such a long drive from Louisiana because we went through Houston and we never should have done that. It would say, there would be a sign that says you are leaving San Antonio. And we were like, quick, get off the freeway. And of course, we're not, I found out we were so not leaving San Antonio. So I'm still learning. So TAP recommendations. So who's in the home where you would be staying?
An older lady friend of mine.
Well, what is your relationship with her?
just friends. She took me in whenever I was out there struggling, trying to get me right.
Does she have children?
Yeah, she has a son,
Age?
my age,
Oh,
he's 36.
she has a 36-year-old. When are grown people going to get their own place instead of living with their mom? At some point, kick people out of the nest. So when is she planning on kicking him out of the nest?
Got no idea.
Now she has two grown people living in her house. All right, check on that location to see if it's appropriate. And I'm going to want field visits one time per month until further notice. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. Actually, I'm going to give him 45 days because his criminal history is such, it's going to be a little bit difficult for him. So 45 days upon release. Ms. Abrams, is there anything else he needs?
Your Honor, in regards to his community service hours, are you willing to give him any credit for his parenting class?
Yes. So once he completes parenting classes, he will be done.
Yes, Your Honor. And nothing else on my end.
All right, is there anything you need from the court to be successful on this probation?
Um,
All right, any mental health issues or anything like that with you? All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeals, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. You're gonna have to do better. If you don't do better, you're looking at 7 years in prison. So from here on out, everything you do, you need to ask yourself, is this something that could result in me going to prison for 7 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. And that lady who decided to take you in and now she will have you, a grown person, and her grown son live in the house, make her life easy. Don't bring drama to her doorstep. Don't be fighting over what people get to watch on television. Mow the lawn, do something to help her to earn your keep. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you. Who's here on Jeremiah Escoto Martinez?
We approach.
Yes. Yes, sure.
Nah, pretrial or lack thereof.
Yes.
Yes, Your Honor. This young man is been recommended for pretrial diversion. This is my fourth trip here attempting to get that done. He typically arrived with in company of a big brother, big sister volunteer. In fact, she's the one who paid for his lift to come here today. He doesn't own a bicycle. He works at night at Burger King. Apparently, I talked to my staff and they told me that his volunteer for pretrial this morning, but nothing has been submitted.
All right, so let me ask you something, Mr. Escoto Martinez.
Sir.
How old are you?
19.
All right, so you have a big brother or big sister?
So
All right, so I understand that, and I understand people need help, but you're gonna have to take the VIA bus maybe. Are you able to do that?
yes, ma'am.
All right, so sometimes you have to do that because this is important, because I was this close to issuing a bond forfeiture, which means you would be in the Bexar County Jail. You understand? When you have a court date, you have to show up for that court date. And I know you knew about this court date and you had a reset form. You understand?
Oh, no, Your Honor, please. But I understand though.
All right, you're gonna get a reset form today. You need to fill out the paperwork for pretrial diversion. If you don't fill it out, and if it's not given to them today, when you come back here the next time, I'm not doing that. This case is gonna move for a jury trial. You understand?
Yes, Your Honor.
Is there anything that you do not understand? Any of my instructions?
No.
All right, so Ms. Ferguson, can I give me a date for pretrial diversion?
Yes, ma'am. I can do August 14th.
All right, so you're going to get a reset form for August 14th. That means you need to be here on August 14th at 9 a.m. If you are taking the via bus, you just need to make arrangements and see what the bus routes run.
3 mile walk, he can walk. Wouldn't
Yeah.
take that long.
Yeah, I understand. I used to walk. Believe it or not, I used to walk every day to the Bear County Jail because I didn't have a vehicle, and I would see my clients walk. There was a bondsman who had a Coke machine, and I would grab a soda from him because it would be so hot. And I would take the via bus. And for people who are afraid to be on the bus because, oh my gosh, I don't know if I'm going to get on the right route or not. You know, my mom would always tell me, she's like, Stephanie, when you get on the bus, ask the bus driver, does this go here? They'll tell you and say, no, you need bus number 23 or whatever. So you just have to ask, okay? And what I can tell you is, if you're running late, if you can get the 90 bus, which is the Babcock bus, that's the bus that goes on the freeway. It'll get you downtown quickly. If you want to do a leisurely ride, maybe you have some lunch or you're eating breakfast, take the 92. That's the Frederick Burke's bus, and you'll get to see a lot of people. If you get on the Looper, you're in trouble because that Looper is exactly what it says. I made a mistake and got on the 551 time, and it's the Looper. It will take you all the way to the bases. And I just sat back and enjoyed the scenery. I'm like, oh, well, here I am. But yeah, so you can do that, okay? All right, Ms. Ferguson, if you give him his reset form.
Wait right there.
Thank you, Your Honor.
You're welcome.
Wait right there. Thank you.
Yes, sure. Thank you. Norma, Antonio Casablanca was recent.
Yeah, I got that.
Okay, thanks. Alexander Castro. All right, thank you. Jason Wilson. Jason Wilson. Arthur Beecham. Deputy Laura, I got off track with my water intake, so I'm back on it.
You have your large bottle.
Yeah. Hey, it's behind. All right, who's here for Ruben Ariana?
That's me, Judge.
Yes.
I came in yesterday. He wasn't here. I had no way to contact the fellow. There's been a couple of VRs, and when I look up his case on the public database, it does not show, which is the hint to all of us that there's a warrant, because if the case doesn't exist on the public database. So I think the reason he didn't show up is because he has a warrant, but I don't know.
All right, Caroline, can you check to see if he has a warrant? Do you need the case number?
Huh? I wonder why. Maybe I looked it up wrong.
All right, did you have a chance to contact the bondsman? Did you want to call the bondsman?
No, I'd like to have that opportunity. When I left here yesterday, I had it in my head that he had a warrant and I thought that's why he wasn't here. But since he does not yet have a warrant, I'd ask the court to hold back on that. Let me see if I can bring him in. And give me 2 or 3 days. And if we come in with a darn good explanation, maybe you'll choose not to. have a
I'll give you till
warrant.
12.
Okay.
So if you want to call the bondsman, I'm sure the bondsman
Well,
probably has
they
a
have
number.
Real
Yes,
interest in getting him here.
yes, so,
All right.
all right, 12. If
Thank
you'll
you.
come back here at 12.
Yes, ma'am.
And sometimes we're just waiting for attorneys to show because they have a lot of cases. So they have about maybe 8 courts to be in. Yes. Oh, they're moving through all different courts. Yes. And then sometimes they're on the civil side. Defense attorney. No, the prosecutors are assigned to a specific court unless they're in a special division. For example, Jordan Brown, who came down, he's in a specific division. So he goes to different cases, different courts, but everybody else, they're usually assigned to a specific court. Yes. Arthur Esparza. I'm sorry, Javier Esparza. All right, on this case, there's DNA issues.
I think the issue is that it hasn't come back yet. And I was just calling, I was in the back calling multiple people and I still don't have a firm answer, but from what I can tell, it has not been returned.
So when are they anticipating? Where is it in the lineup?
It was submitted March 3rd. So
March or April?
March. Okay, March 3rd.
Okay.
I did get confirmation of that. The analyst who's handling it is apparently on vacation right now. So hopefully I can get a firmer answer, but I can't give the court an exact.
Well, people need their vacation so they can do it correctly.
I would agree with that, Your Honor, and I desperately need one. I forgot my iPad this morning, hence I'm just standing
Oh,
here.
you're just standing here.
So,
That's okay. You have it up there.
That's what everybody's telling me, so we'll fake it.
But the lab is not DPS, so that makes me think that might be quicker.
All right.
So it's a lab.
There's someone at the door who wants to come in.
Yeah.
But I guess he doesn't want to knock. Ms. Ferguson, can you reset this for September?
It should be in by then.
It should be here by then?
Yeah, hopefully it'll be here by then. And of course, I'll get my e-discovery notice and I'll bring in, well, I'll confer with Brittany off docket and see if we can get more answers before court.
All right.
September 12th.
Okay.
You don't know.
Well, I'm having to reschedule my tonsillectomy
Mhm.
and I'm trying to move it up. I will notify the court. I just don't have a date, so I'm clear as of now.
All right. Oh,
I got COVID, so I had to delay my tonsillectomy from this spring. I was supposed to have the surgery this spring.
all right. I had that surgery when I was in elementary.
Okay, then we can't talk, but okay.
But let me just tell you what happened. So I needed it done. And I don't know if my mom really needed it done or not. I'm pretty sure she did, but you know what she did? She scheduled hers the same time as mine was scheduled. So we were actually in the room together. And that whole thing about eating ice cream, it doesn't work. It's very painful. So my mom was pretending as though it wasn't painful. So she's talking. I tried to talk and just no. I started, but it helped me with spelling because I started writing everything down.
So I will come and talk to you because if your mother had it as an adult, I've done my research and I've learned that the recoveries are very different between children and adults.
Well, you just have to pretend as though there's a child next to you and you've got to pretend like it doesn't hurt, but I'm sure it was painful. But you just got to pretend, oh, Stephanie Boyd as a child is next to me in this bed. So I got to pretend like it's okay. Let's eat. I would not eat anything. The Jell-O, no. When they say, oh, you get all the reason a child should worry whenever somebody says, you can have all the ice cream you want from this surgery. That's because they know you can't. To swallow hurts. It was just very painful. And you're just like,
My mom has lots of funny. I was 8 when I had mine out, and apparently I woke up from anesthesia. I was saying, "Mommy, I'm dying."
oh my gosh.
And then
Yeah,
I was
I'm
mad because
feeling-
they don't let you eat ice cream because the dairy will make mucus or something.
Mucus,
So
yeah.
I had a bunch of orange yogurt.
Yeah,
It's my memory.
you guys are making me feel a lot better.
No, it's going to be painful. I mean, but
I'm
each
okay
time
with-
you get ready to complain or you don't want to talk because it's too painful, just imagine
There's a
the
child.
elementary school age Stephanie next to you and you're trying to make her think it's okay.
Yeah. See, my thing, I'm okay with pain. I'm not a baby when it comes to pain. I'm fine with the pain. It's the not eating part of it that's really scaring me because that's a whole nother level of,
The whole swallowing, that's just off the table.
yeah, that's what I mean. Like there's no way to get around eating food and taking in protein and nutrients without
At
swallowing.
least I think as an adult, you can probably have more like lidocaine or something.
Maybe that's what it is, but they
Don't
still
do it.
say
Just do it
no.
old school. My mom did it
No
old school.
pain.
You can too.
We shall see. We
All
shall see.
right.
But I'm calling the doctor today to find out. So
Okay.
I'll let the court know. if I
You have to
change
come
it.
back and let us know how it was.
Well, I'll be back eventually. Knock on wood. That's the ultimate goal. I'm coming
Yes.
back.
When you come back though, let us know how it was.
So excited.
All right, Ms. Ferguson will give you a reset
Okay,
form.
go ahead and have a seat.
Tevin Towns.
Thank you.
Present.
Yes.
And that's where I was doing the whole thing. So I'll go back and grab it.
Hello. And counsel, you're on this side and your client's in the
Yes,
middle.
ma'am.
All right, so where are we? We were set in May 15th and I brought you all Back in July. So you had the whole month of June. And
Yes,
it was CPS records and a video of the complainant statement.
yes, Your Honor. CPS records, it's been determined they do not exist.
Okay.
So that question has been answered, Your Honor.
And the complainant statement.
I don't remember still receiving anything in regards to the complainant's statement, Your Honor.
Let me see here.
I think the complainant was in court last time, Your Honor, and provided information to the state.
But it's supposed to be a video
I
of the
believe that
complainant
is,
statement.
I believe that's correct, Your Honor.
All videos in the state's possession are uploaded to e-discovery, Your Honor. I can't speak to whether that video in particular is on there, but
All right, let's see.
Espinosa and Guzman.
All right, we're gonna see if we have the statement. And do you know, is that video with supposedly with SAPD or somewhere else?
I believe it's with SAPD, Your Honor.
Okay.
In addition, Your Honor, just educate the court, an offer has been made.
Okay.
We have countered that offer. They are going to try to determine if that is something that they are willing to do, if it's within their power to do.
All right. And do we have any idea what's on this video?
The only thing I know, Judge, is in the written report, it states that there was a video made with, concerning.
I mean, I can say, Your Honor, there's over 20 videos that have been uploaded. I can pull them all off e-discovery and we can go through them one by one and see it. I don't know if you want me to do that right now with the court here or.
Ms. Just one second. Ms. Ferguson, this case, can we recall it for the week of July 24th? Will you be here, counsel?
If you could give me an opportunity to check very quickly, Your Honor.
That will give you all 2 weeks for this video.
I will be available on that date, Judge.
All right, the week of the 24th, Ms. Ferguson? All right, so July 24th. That's for the state to have the video, and it's also the plea deadline date. Of course, if the state doesn't have the video, then your plea deadline date will be extended because I know you need to see that.
Okay.
So July 24th will be your plea deadline date if you receive the video. And you all need to confer off docket for him to give you the video.
I will do that, Your Honor, but I appreciate the court's time, Judge.
All right, is there anything else that's needed?
Nothing at this time, Your Honor.
All right, once you sign the reset form, you and your client are excused.
Thank you very much, Your Honor.
You're welcome. Who's here on Edward Castillo Bringas?
I am, Your Honor.
We find the state real quick, Judge.
Okay, thank you. All right, good morning. You want to have a seat? He's trying to find the prosecutors on this case. Sure. So PTD is a pretrial diversion program that they have. So what happens in pretrial diversion is, let's say you were to have a criminal charge, maybe a drug case, and usually I see them a lot in drug cases. What the state will say is they'll offer you a pretrial diversion. So they will give you things that they want you to do, like classes or something like that. And once you complete that, then they'll dismiss your case. So you won't have a conviction on your record. Yeah. Usually it's, yes, usually it's for drug cases, but it's within the state's discretion. So usually it's people who don't have any prior convictions, and maybe this is their first case. For example, sometimes with drug cases, you have college students. There have been times where I've represented college students who have one Xanax pill or one ecstasy pill. Those are all felonies. And of course, if you give them a felony conviction, then there are a whole host of collateral consequences for that. One, you're not going to get any financial aid. Two, there's going to be issues with you staying in the dormitories because that has to be reported and you have to report it. So there are a lot of collateral consequences that happen with convictions. And sometimes the DA's office may say, I don't want to give this person a conviction. Even deferred adjudication is a form of probation, but it's a form of probation without conviction. But the difference between a pretrial diversion and a deferred adjudication is on your record. So when I first started practicing in '97, if you had a client who got deferred adjudication and they were trying to get employment, the employer would never ask if they had a deferred adjudication. The question would be, have you ever been convicted of a felony? And your client could honestly answer no. But employees start learning about deferred adjudication. So now they will ask, have you ever been convicted or placed on deferred? They ask all these questions. So the pretrial diversion is much better than having a deferred adjudication.
Oh, he's on. Is he here? Oh, okay.
Oh, no, the lady who zoomed in, that's pretrial services. That is a completely different division, and I'll explain that to you. But for the pretrial diversion, what they do is the state will review the person's criminal history, and then they have a group that will look over it and say, yes, this person should get pretrial diversion or no. Now, sometimes you'll have people who are supposed to have pretrial diversion, but they fall through the cracks in the sense that they don't report, they don't fill out their paperwork. And then they don't end up with pretrial diversion because they just blow it off. No, their case continues. So for example, some of the cases I have, when you see me giving them a reset for pretrial diversion, it is because they need to do certain things. So, and first of all, they have to file an application. Then it has to be approved, and that takes some time. Right. Jose Soto Victorino. Hello, where is he? Ah, come down. Oh, he's a Spanish speaker. Ah, okay, just give us a moment.
Oh, well, it's just for the update too.
Yes.
Okay.
Miss Ferguson, can you call an interpreter down? Richard Garcia. I'm going to tell my mom you said that. You know, I was supposed to be in Louisiana, so French is my thing.
You know, a year ago, we were in Barcelona.
Yes. Oh my gosh. You know, that's popped up on my feed. They had some of the best shrimp and the best mussels. I have to go back to Barcelona. We were. All right, could I see Paul Cochran?
Yes, Judge.
All right, where's your client?
He's right here. Paul.
Hello, Mr. Cochran. How are you doing?
Doing fine, ma'am, Your Honor.
So, Mr. Cochran, the state has presented a dismissal. I don't know. Could everyone please whisper? I don't know the circumstances behind this case, right? But how old are you?
60. I'll be 60 next in March.
Oh, well, happy pre-birthday.
Thank you.
Yeah. But this is what I do know. Whatever brought you to this court, if there's a relationship issue, because obviously for you to be here, I know they're dismissing it because they're saying it's insufficient evidence, but whatever brought you here, there had to have been some sort of confusion, right? So if you're in a relationship with somebody, whatever confusion there was that brought you here, unless that's addressed, that same confusion is going to be there when you all get back together, if you decide to get back together.
I'm not going back that way.
Okay. All right. But whatever confusion that is, if it's something with you, I always tell people get an orchid. And if that orchid survives for after the flowers drop off and then flowers reappear, then you're ready for a relationship. But if you keep dumping that orchid in the trash because it's not going well, you're not ready for a relationship. So get an orchid.
Yes, ma'am. I'll get one.
All right. Oh, don't.
No, I'm sorry.
You guys try to stretch through there. That's not going to work.
Try.
All right. Good luck to you.
Thank you, ma'am.
You're welcome.
I'll meet me outside. I'll make a copy of it.
Okay.
So what ends up happening is that case was a dismissal. So the state is saying they don't have enough evidence. When something is indicted, all you need is, you don't need proof beyond a reasonable doubt. So if somebody says something happened and you believe it happened, and you can file a motion, you can take it to the grand jury, have them indicted. Once they indict it, then it comes to court, and then the state will look at it and see whether or not they can prove the case beyond a reasonable doubt. And if they deem they can't prove it beyond a reasonable doubt, they don't take it to a jury trial. They're supposed to file a dismissal. Now, on my end, I'm not supposed to be, I don't look at police reports and say, oh my gosh, let me see if it's proof beyond a reasonable doubt, because that's not my call to make. Now, there are some cases, for example, and this is just me, if there's a person who's charged with injury to a child or a child offense, and the state wants to file a motion to dismiss it, it's missing witness, I want to know who the missing witness is, because I've done child protective services cases before. You know what ends up happening over there? If there's a case that child protective services want to bring in and somebody says these children are in danger, they would come knocking on their door and say, hey, will you let me in? No, I'm not letting you in. And if they try to make contact a certain number of times after that, they just don't even do anything else with the case because they say, we couldn't make contact with the children. I don't like to do that. So if somebody has a child case and it's missing witness and the missing witness is a child, I need child protective services in here to say, I've tried, or what happened with that case. And people can say that's not my job, but I think part of my job is to protect the community, and children are the most vulnerable people in a community because one, they don't vote and they're 100% dependent on whatever adult is in their life. It depends. For example, I've had people come to court and they're high. And when I say high, meth, marijuana, opiates, everything. And then they tell me, oh, I'm going to go pick my children up from school. I'm like, somebody please call CPS. And so we had someone come in before and CPS came in and talked to them and they wanted the help. They got the help. CPS got in contact with the children, because the last thing I want happening on my watch is because I didn't do something, a child dies. My mom always reminds me all the time when she was growing up, there was a case where a mother was high on drugs and she thought her child was a pig and put the child in the oven with an apple in its mouth and killed the child. I don't want that on my watch. So. Yeah.
Here's a fun thing about this case.
Mhm.
It was actually indicted. Didn't have any kind of shame.
Hi, we have the interpreter here. Yay. Good morning. It's always great to see you. I know it's going to be a good day when you come down.
Oh, you're gonna make me cry. I feel exactly the same way.
Oh, thank you. Jose, we're ready. I'm loving the colors today.
Thank you.
The pastels. The pastels are great. You know, I always believe that there's a specific color that is somebody's color. You know, you just pop when you wear it. That's your color.
Thank you. Well,
All
I'll
right.
take note of that.
You're
I think this is
welcome.
the only thing I have in this color.
Hey, now you need to get more.
Right.
I always think when people look great, you need to tell them they look great. You know, people have a great day.
Thank you.
All right, so let me ask you, could everyone please whisper? On this case, is he a citizen or no?
He is not.
All right, so do you have an immigration attorney or no?
No, he does not. He does have an ICE hold. He understands that probably despite any result in this case, he will be transferred to ICE custody, and he would like to just ask for voluntary departure to Mexico, his home country. He doesn't have any intention of like pursuing an immigration case or anything like that to try to remain here.
Okay, all right, even though that's the case, I still want him to have an immigration attorney unless you're going to do the immigration work to let him know what will happen in these cases.
Okay, I am not going to do the immigration work. I can reach out to the, he's court appointed. I can reach out to the MAC office to see if they have the resource to do that.
Oh, they do. So we'll make sure that he has an immigration attorney.
Okay, perfect.
Now, the last time we were here on May 1st, we were to come back on June 29th, then we reset it because I wasn't here.
Yes, sir.
And it's to see whether the feds are picking this up or not.
My understanding is no, Judge, from what I've at least been taking a look at the case, no one's made it apparent to me that that was gonna happen.
All right. So counsel, do you have all the discovery?
We have lots of discovery, Your Honor.
And Judge, that's kind of what we were gonna talk about specifically in this case. So we have about a box full of discovery specifically related to this case. And it's taken quite a bit of time to even get through a good chunk of that.
Okay.
And so specifically, I'm trying to look at the discovery in regards to this defendant and his involvement.
Okay. So what I want to make sure that we do is I don't want him to get picked up because sometimes the federal government does what they want to do and then we'll just have this case out here. So how long do you think it will take you all to work through that or?
A couple weeks, not an excessive amount of time, 2 to 3 weeks, just because I really just need the time just to have a chance to sit through and look through everything.
All right. So Ms. Ferguson, on this case, one, if we can make sure that Mac knows he needs an immigration attorney, see if they can bring somebody down now.
Sure.
And if you could stay, because I don't know if the person who's coming down is able to speak Spanish or
Oh,
not.
I see. Sure.
Do you speak Spanish? Oh, wow. Okay. So, and then can I get 30-day reset for discovery? And if you all have it sooner than then and you want to come back, just have Ms. Ferguson and she'll put it on the docket.
Okay, perfect.
All right, August 30th. Mr. Soto, is there anything else you need? Any questions?
No.
All right. Thank you.
Thank you, Your Honor.
Thank you. It's all good seeing you. Thanks for coming down.
It's my pleasure.
All
You
right.
made my day. May I be
Oh,
excused,
thank you.
Your Honor?
Yes, have a great one.
Thank you, you too.
For discovery again.
Yes. All right, whenever you all are ready on Bring Us, let me know.
Yes.
All right, the party's on Blas Casamero. And have you all had a chance to confer with probation?
had a chance to speak with John.
All right, if you all will speak with her, please.
Thank you.
So everyone, if you have a motion to revoke, please confer with probation. That's the polite thing to do. And the people on Stephen Salinas, did you confer with probation?
We have to.
Yes, Your Honor.
Ah, thank you. Now it's coming fast and furious. I like this. And the people on Jose Coronado, did you confer with probation? All right.
And we confer with the state, and I think she's ready to make an agreement.
All right, just give me a moment. I'm going to take up first Stephen Salinas. Stephen Salinas?
Yeah, we're present, ready, Judge.
All right, if you come down, please. Court is calling 2015 CR 12154, State of Texas versus Stephen Allen Salinas. Can I have parties announced for the record for the state?
Travis Banks, the state of Texas.
Defense?
Robert Gear, Your Honor, for defendant Stephen Salinas, and we are ready.
And are you Stephen Salinas?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
I did.
Are you the same Stephen Allen Salinas who's placed on deferred adjudication in 2015 CR 12154 for the offense of continuous violence against family on March 16, 2016 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2 on or about the 19th day of October 2020 in Bear County, Texas. The defendant, Stephen Allen Salinas, did then and there illegally use a controlled substance, namely cocaine, in violation of condition number 2.
Just one moment. How do you plead to that? True or not true?
That's true.
State,
The state will waive and abandon the other allegations.
any objection?
No objections from defense, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
That's true.
Do you still wish to plead true?
Yes, ma'am.
All right, the court will find violation of condition number 2 true. Is there an agreement?
Yes, Your Honor, the agreement and recommendation, should Your Honor choose to follow it, is to revoke the defendant's community supervision, to sentence the defendant, to adjudicate the case and sentence the defendant to 2 years in the Texas Department of Corrections, and give him credit for any time he's already served.
All right, why should I sentence him to the minimum? Has he done anything on probation?
Yes, Judge, may it please the court. Defendant was charged with continuing violence. He did attend and complete the BIP course in this matter to address that. There was also some allegations of drug use.
Just one second.
Sorry.
All right, you may continue.
Yes, Judge, sorry. In addressing the alleged drug use, he did attend and complete the Bear outpatient program in this matter. Because of these charges, there was also CPS intervention with the.
Why are you crying?
Because I lost my son.
In what way did you lose your son? Did he pass?
No.
All right.
Because of this.
All right, so you lost your son because you didn't do what you were supposed to do. That's what these are called consequences.
No.
You may continue.
Yes, Judge, thank you. CPS intervened and he had to take multiple classes in regards to CPS, parenting, counseling, the whole works over there. He also did complete 117 hours of community service in this matter, Judge. The one allegation of drug use was from October of 2020. Judge will look at the back page. From then until he was expired in March, there was a whole page full of negative tests between then and the expiration of his probation. We understand that we're here because he was not a perfect probationer, but we will front to the court that he did do quite a bit of what he was required to do, including the classes, the community service hours, and tending to the issues made the basis of this case. Thank you.
All right, state, why should I follow this agreement?
Your Honor, I would echo what defense said, because he completed many of the terms on probation, drug treatment. And at the end of his probation, he was providing negative drug tests on his UAs.
All right, probation, is there anything you wish to say?
Your Honor, the case expired in 2021, so we're past the year mark, jurisdiction and so forth. The recommendation from probation is to revoke or terms unsatisfactory if the balance is paid in full.
All right, so where, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand and state your name for the record.
That's Steven Salinas.
All right, Mr. Salinas. So what happened with your CPS case?
Well, like,
Were your rights terminated?
yes, ma'am.
And was your son adopted out?
He was.
Is it to people you know or not know?
I mean, it's to her family, but you know, it's hard to see him.
All right. So when's the last time you used before you were taken into custody?
Last time I used,
Mhm.
a long time ago, ma'am.
When is that?
I mean, October of 2020, like I really don't do anything. I go to work. I mean, I drink beer after work, but that's about it.
Can't be drinking beer because that causes slip up. Don't change one addiction for another.
Yes,
It's sort of,
ma'am. Yes, ma'am.
when I see a lot of people in treatment, guess what? They don't use cocaine or whatever anymore, but they chain smoke. So you've got to do better. You understand?
Yes, ma'am.
So did you have employment?
Yes, ma'am. Like I've been a technician for Sun Auto for about 3.5 years, and then the last couple months I've been self-employed as a mobile mechanic.
Okay.
You know, on top of that, I was just about to go to college and everything before I got picked up. And I did check to see if there was a warrant to take care of this, but
I mean, did you think this was just going to go away?
I mean, I didn't know what happened after, just after my PO told me that probation was over, and then when it came time for just for me to get my ID, that's when I was calling in to see if I had a warrant to take care of all this, and I would have been here sooner.
All right. And are you still in contact with Savannah Franson?
I haven't spoken to her in years.
All right. Is there any other questions from either side?
Nothing further from defense, Your Honor.
Well, it appears that he completed all of the conditions that were asked of him. It appears that he hasn't picked up any new cases. Am I right?
That is correct. Your Honor.
And the cocaine positive UA is from 2020.
You are correct, Your Honor.
And so we're in 2023 now.
That's correct.
And so is there any suspicion that he has used beyond that 2020 date from either side?
State has no evidence of that.
Judge, from defense, we have no suspicion. I know from chatting with him, he's been employed, gainfully employed. And I would assume that continuously gainful employment would negate the use and the consequences that stem from that, Judge.
All right, this is what the court is going to do. The court is finding violation condition number 2 true. There is to be no contact with Savannah, SAVANNAH, Francine, FRANCEN. And if it wasn't stated before by the previous judge, there's an affirmative finding of family violence. Court will deny the motion and terminate you on set. Is there anything else from either side?
Nothing further from the state.
All right, we can go off the record. You are going to have to make better decisions. You understand?
Yes, ma'am.
When you have an obligation, you can't just think, oh, I'm doing great, so I don't have to answer to the obligations. Part of drug treatment is making amends. And part of making amends is making amends to people that you've entered into contracts with. You understand?
Yes,
The
ma'am.
only reason why I'm terminating you on set because these allegations are from 2020. According to the probation report, it shows that you've done everything that you were supposed to do on probation. Yes, you owe some court fees, but it's not due to restitution. Are we off the record? Okay, I just want to make sure. All right. With regards to your child, you know the people who have your child.
Yeah.
Sometimes in CPS cases, strangers adopt children and you don't know who have them.
I know.
So you need to straighten out your life. I don't know what your relationship is with your in-laws or what's going on, but I do know that sometimes if someone has a child who was with you, right? And they are not the child their parent wanted to be, sometimes the parent blames the person who was with them. So you need to better yourself, and maybe if you get your life together, 100%, they'll let you see your child. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome. Jose Coronado.
I be excused, Judge?
Yes, you may be excused. You're welcome. Oh, Coronado, who's the attorney for Jose Coronado? Oh, thank you. Court is calling 2022 CR 11927, State of Texas versus Jose Coronado. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
David Andre Woodard for Mr. Coronado.
And are you Mr. Coronado?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jose Anthony Coronado who was placed on deferred adjudication in 2022 CR 11927 for the offense of retaliation on January 30th, 2023 for a period of 4 years? Is that you?
Yes.
State.
Yes, Your Honor. Violated condition number 13. On or about the 12th day of May, 2023 in Bexar County, Texas, the defendant, Jose Anthony Coronado, did then and there fail to apply for, provide documentation of attendance, and comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following program: anger management class, in violation of condition number 13.
How do you plead to that? True or not true?
True.
Judge, we waived the other violation alleged in the MTO.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 13, the court could find the true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 13?
Yes, ma'am.
Court will find violation of condition 13 true. Is there an agreement?
There is, Judge, the agreement is for 2 years incarceration.
All right, is that the agreement?
That's our agreement, Judge. I'm just asking the court to follow it.
All right, why didn't he do the class or sign up for the class?
I believe talking to my client, Judge, there was financial issues with paying for the class and things just spiraled. And he just never enrolled in the class.
And what is going to happen to the alleged new offense?
It's going to be dismissed.
Yes, Judge, that's right.
Okay. Thank you. All right. Is there anything you wish to say, Mr. Coronado?
No, ma'am.
All right, then the court will grant the motion, find you guilty, not grant you community supervision, sentence you to 2 years in the prison, give you credit for any time served, and there's $1,000 fine. Time and money will run concurrent. Is there anything else with regards to sentencing?
No, Your Honor.
No, Your Honor, thank you.
All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. We can go off the record. How old are you?
36.
You're gonna have to do better. Don't be the person who's at the prison when somebody shows up and say, how's this run? And they say, let's ask the oldest person in the prison. We call him grandpa. Don't be the grandpa at the prison, okay?
All right.
All right, good luck to you.
Thanks, Judge.
You're welcome. Who's here on Eduardo? Are you guys ready on Castilla Bringos?
Sturgis. Coronado.
Okay.
Salinas.
All right, what is happening on this case?
Judge, we've submitted an application for pretrial diversion. The DA's office is going to review it and get back to us whether or not it's been accepted in that.
Yes, Steven Salinas.
All right, Ms. Ferguson, I need a PTD on Castilla Bringas, please. And remember, he has duty. Yes, when do you leave?
16, I'm heading on the plane.
All right, the 16th of this month?
Yes, because I start the school, it's virtual, the first part, so it starts Monday, and then I gotta hop on a plane Sunday.
All right.
To get to Port Eustis, Virginia.
All right, so when do you come back?
August 19th, I believe.
August, so if you can place it sometime after August 19th. All right, does August 24th work?
Yes, Judge.
All right, if you'll sign the reset form, then you're excused.
Thank you, Judge.
You're welcome. Who's here on Blas Casimiro? Court is calling 2023 CR 1288, State of Texas versus Blas Christian Casimiro. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Forrest Good on behalf of the defense.
And are you Mr. Casimiro? Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Blas Christian Casimiro Jr. who was placed on deferred adjudication in 2023 CR 1288 for the offense of evading arrest or detention 2 or more on April 25th, 2023 for a period of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Blas Christian Casimiro Jr., the then and there failed to report to the supervision officer as directed on May 25th, 2023, in violation of condition number 4.
How do you plead to that? True or not true?
Not true.
That state waives all the violations, Judge.
Any objections?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there an agreement?
Judge, there's no agreement. We're going over to the court.
All right, state, what are you requesting?
We're requesting 18 months in the state jail.
Defense, what are you requesting?
We're requesting a state fee and a continuation of probation.
Probation, what is your recommendation on Mr. Casimiro?
Your Honor, recommendation is revocation.
All right, what I can tell you, because your client has 2 pending offenses, they're not going to accept him. So I don't know, what has he done on probation?
Your Honor, he failed to report to probation. He hasn't done anything.
He had a very rough start, Your Honor. And it was only until before he got arrested that he was starting to make moves towards being able to
And why was he arrested?
possession and trespass, Your Honor.
See, the number one rule when you're on probation is don't pick up any more cases. Not only did he pick up more cases, but he hasn't done anything, didn't report, didn't do anything. There's nothing for me to do with that. He hasn't done anything. Obviously, he doesn't want to be on probation.
I do know this is, when I called, I was at the hospital, I was sick, I had a
All
fever.
right, you want to raise your right hand for me?
Yeah.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Blas Casimiro.
All right. So here's the thing. You're under oath. That means the state can get you, is allowed to ask you questions. You understand that?
Yes, ma'am.
So for me, the fact that you were in the hospital, allegedly, it didn't stop you from picking up a criminal trespass in a drug case.
Yes, ma'am.
So again, we're back to the point. Why can people not report? That's the easiest thing to do. You just report. If there's an issue, if there's a drug use issue, if there's a mental health issue, I'll address that. But I cannot have the report. And not only did he not report, he allegedly picked up new cases. And I remember this case. I'm the one who wrote everything down. And I wrote this down based upon my evaluation of him, and he did nothing. All he did while he was on probation was pick up new cases. So there, I can't help him. He doesn't want to be helped. And sometimes you can't help people. All right, I'm going to find you guilty, grant the motion. Counsel, do you want to speak? The state is asking for 18 months.
We asked for a year.
All right. So then the question becomes, what is his criminal history? Why are we at 18 months? Because I can
Judge,
sentence you to the full 2 years.
the main reason why I did 18 months, as far as I could tell, there was no violent criminal history that he'd been convicted on. There were a few cases. It was also due to the fact that since he was on deferred, and he did nothing, that was another consideration why I went more than a year.
Thank you. All right, counsel, anything you wish to say?
I have nothing further, Your Honor.
All right, the court is going to sentence you to 18 months in the state jail facility. I'll give you credit for any time served. If you would like, I can request that you be placed in the therapeutic community. It doesn't increase your time in the facility, but it's just something that may can help you if you have a drug or alcohol use issue. Would you like that?
Yes.
All right, so I'm going to ask for the therapeutic community as well.
And Judge, the state will take into consideration the 2 other open cases.
Okay, and then the state is saying that they're going to take into consideration the other cases, so you won't have those. I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, this is not a plea bargaining agreement, so you do have a
So what is
limited
this?
right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're off the record. You have a question?
So I'm going to prison, right?
You're going to the state jail facility. It's slightly different from prison, but it's still prison.
All right, thank you.
All right, you're gonna have to do better. You understand?
Yes, ma'am.
All right, good luck to you, okay?
Thank you.
Who's here on Jason Wilson?
They're dropping.
Hi, good morning.
Good morning. So what is happening with this case?
Judge, I've reviewed the case. I believe the defense counsel is going to bring me a packet for mitigation before I make an offer.
All right, so do you have all the discovery defense?
I believe so, Your Honor.
Mr. Locke's associate attorney, so I accessed it and I believe we have everything.
All right, Ms. Ferguson, on this case, can you give me a 30-day reset? No, it's going to be for the state to make an offer. All right, we're going to come back on August 7th. So council, whatever you need to give to the state for them to review to make an offer, it needs to be done before then.
Thank you.
All right, once you receive the reset form, you're excused.
Thank you.
Thank you, Judge.
Andy Fuentes. And where's Fuentes? All right, we were here last time. The state wanted to speak with a witness. So where are we?
Yes, Your Honor, we have we have been in contact with SAPD and the detectives that were handling this case and canvassing for potential other witnesses, Your Honor. We've not heard back from SAPD at this point. However, we are unaware whether or not there exists any other witnesses. At this point, I've spoken with counsel, and I believe she has attempted to get her investigator, or has yet to attempt to get her investigator. But there's potential other statements still outstanding on it.
And Judge, we will be scheduling a meeting with my investigator, but he has interviewed some. We have some others that are still not interviewed. And basically, Judge, this case is still under investigation. I'm hoping that you will just allow us to have another reset and let us make sure what needs to get done on this case does get done.
All right, Ms. Ferguson. On Fuentes, I'm going to want a 45-day reset, and this is going to be your plea deadline date. The court will not extend it any further.
Yes, Your Honor.
I'm sorry, August the.
She's about to give it to me. Hi.
Your Honor.
Hi, Johnny. How's it going?
Doing good. How are you doing?
All right. Long time no see.
I know I've been hiding. How's your mom?
Oh, she's doing great.
Give her a big hug for me.
All right. I will hug mom for you, Johnny.
Thank you.
I can do August 21st.
All right. August 21st. That will be your final plea deadline date.
Is that a 45-day setting?
Ms. Ferguson?
Hold on. Let me get 45 days back.
It's not, I just not good with them.
6.
45 is exactly August 18th. I'm gonna push it to, that's a Friday, but I gotta push it to August 20th.
Okay.
All right. August 21st.
Thank you, Your Honor.
All right. Once you sign the reset form, you're excused. Gaspar Rodriguez.
Good morning, Your Honor.
Good morning. Hi, so what's happening with this case?
Good morning, Your Honor. So I asked to get put on the docket today. He's an inmate. State saying they do need to contact the victim in the case, make sure they're whole before we can receive an
Why is
offer.
he in red?
I don't know that, Your Honor. We have to ask.
An inmate fought with me in the jail and tried to take my plate and told me it's just a long story, so I just got into a scuffle.
All right. Do you need me to let the deputies know anything?
No, I'm okay.
All right. All right. So state on this one.
So Judge, on this one, there are 2 victims that we have not been able to contact yet. I did see that there was some contact information in the police report, and so I did ask our victim advocate to reach out to them.
All
And
right.
Your Honor, as far as I took myself off the felony wheel back in April, taking a sabbatical started on Monday. So I was really helped. Mr. Rodriguez had been on warrant status for a while. He just came in, so we set him today, hoping to take care of it. I didn't file a motion to withdraw, but I'm gonna be literally in Europe for the next 2 months. So I'd ask.
Oh, a sabbatical in Europe? Where are you going?
It's my 10-year anniversary for being an attorney. It was in May. That was my 10-year passing the bar. So we're gonna go take it. My girlfriend's never been. We're gonna go to Paris and Lisbon, Barcelona.
Oh my gosh, I love Paris.
So I've never been. So I've never been on a good vacations first. So it's my 10-year anniversary as an attorney. So
Oh my gosh, why didn't we, excuse me, how many attorneys who were out for 10 years, you decided you were going to Europe for 2 months? Oh, Richard Garcia, we know you went.
Hey, Richard's my role model. That's why.
Yeah.
We do CPS together.
Yeah. All right, so this is what we're gonna do. Norma, can you have Matt come down? All right, if you'll remain, we're gonna see if we can get an attorney to switch out.
Yes, Your Honor. Thank you.
Okay, all right. And Joy,
Gonna
I
try.
love Paris. If you want any advice or whatever, let me know. I try to go to Paris every year.
Yes. We'll do that.
Yes, I love it. It's my favorite place. Now, if you want Paris, Barcelona, and other places, Richard Garcia.
Yes, Your Honor. We'll take a seat. Thank you.
All right, thank you. Sure. You're welcome. There you go. Who's here on Jonathan Nicholas? All right, I'm gonna need everyone to whisper, and if you are behind the court reporter, you're gonna have to stop speaking. Court is calling 2023 CR 5714W, State of Texas versus Jonathan Nicholas. Where's the prosecutor? Thank you. All right, court is calling 2023 CR 5714W, State of Texas versus Jonathan Ryan Nicholas. Can I have parties announced for the record for the state
Jordan Brown, state.
and for the defense?
Alex Scharf, ready?
All right, if you all are behind the court reporter, there's no talking when we're on the record because it makes it difficult for the court reporter to hear. And one thing I try to do, if possible, is make everybody's job as easy as possible. So no talking in the box when you're behind the court reporter and we're on the record. All right, counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Nicholas, I'm going to show you what's entitled waiver indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, Your Honor.
Did you understand your attorney has certain rights, mainly the passage of 2 entire days from the presentation of the information, and also he has 10 days to prepare for trial. Did you understand?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
And counsel, it's the court's understanding that you've been representing Mr. Nicholas for longer than 10 days?
Yes.
And were you aware about these charges for more than 10 days?
Yes, Your Honor.
And have you received the discovery for more than 10 days?
Yes, Judge.
All right, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled information. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
Yes, Judge.
Okay. I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of child pornography? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Nicholas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There are no applications. This will run concurrent with 2018 CR 520W. The state will take in consideration the following CM numbers: 105406, 105408, 105409, 10510. And there's to be Chapter 62 compliance. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Oh, you're not gonna make it.
Oh, yes. Let's get long range.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence?
Yes, Judge. State would offer states one with attachments. No objections.
Mr. Nicholas, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, can we go off the record for a moment? All right, we're back on the record in 2023 CR 5714W. State, is there any other evidence you would like added to the record?
Yes, Judge, just for the clarity of the record, the report filed as an attachment states Exhibit 1. Most of the dates listed on that are March of 2022.
Yes.
However, the indication in the evidence that's provided in discovery is the date that the material was possessed was actually inclusive of the 6th of December 2021, based on evidence obtained and provided in discovery. And that's the date of the information. And I believe the defense will stipulate that the possession also occurred on that date.
Defense does stipulate.
All right, Mr. Nicholas, do you stipulate to that evidence?
Yes, Your Honor.
All right. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
No, Your Honor, we just ask that you follow the plea agreement.
All right, the court will find you guilty, sentence you to 10 years in prison. This will run concurrent with 2018 CR 3520W, taking consideration CM 105406, 105408, 105409, 105412. There's to be Chapter 62 registration. There's to be no contact with minors. And the court will give you credit for any time served. Is there anything else from either side with regards to sentencing?
Nothing from the defense, Your Honor.
Nothing from the state, Judge.
All right, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. All right, I will tell you, many people think that this isn't a crime. Oh, I didn't do anything. I'm just watching photos. But each time you do that, you are victimizing a child. You understand?
Yes, Your Honor.
So honestly, there's nothing I can tell you that will probably make a dent in your psyche. I'm unsure, but you're going to have to not be around children. You understand? At all. Not be on the internet or anything of that nature. Do you understand?
Yes, Your Honor.
And I remember your mother's testimony, and your mother is enabling you. So you're going to have to be an adult. You understand?
Yes, Your Honor.
All right. Good luck to you. Thank you, counsel. All right. Are we ready on Gaspar Rodriguez? Is someone here from the MAC yet or no?
Yes.
There's someone from the MAC?
Oh, I'm sorry. I'm not yet, Judge.
All right. Just give us a moment.
Judge.
Sorry, I have the last one.
That's okay. Rodolfo Aceve. Oh, hey.
It's good to see you, Judge. Just want to say bye to you and anybody that may be watching at home.
Oh, that would be Mom. Mom likes you, Jordan.
Okay.
All right, you too. Hello.
Hi, Judge. On Rodolfo Aceves, Your Honor, I spoke to the prosecutor.
Oh, let's have him brought down. Where is
Oh,
he?
okay. No, she left. It was just an agreed reset with the court's approval.
Okay. And counsel, you're on this side.
Thank you.
Are you still doing woodwork?
A little bit, yes, ma'am.
You know, somebody told me you're not a true carpenter unless you lost part of a finger or something.
I bought the type of equipment that the saw, if the blade hits your finger, it just creates a little scratch and the saw stops.
Oh, wow.
It's something new.
Hey, all right. So what's happening with this case?
Judge, I've been working on this case for a year, trying to get it to court and file a motion for a speedy trial. He has been on house arrest for a whole year. I haven't been able to get an offer of any sort or anything. So Ms. Carrillo, Miranda, told me that she's going to be talking to people to see if we can get an offer. So I'd like to a quick turnaround on this case.
Oh.
And also I filed a motion to amend the conditions of bond so he can go to work. He's been on full house arrest for a whole year. June was a full year.
Oh, well, you know, I don't get a case until it's indicted, so I have it now.
Right.
So we're going to recall it in 2 weeks.
Okay,
And in 2 weeks, we'll hear your motion with regards to the GPS.
okay.
And then hopefully the state will be able to provide an offer to you.
Yes, ma'am.
All right, Ms. Ferguson. Oh, just 1 second.
Thank you.
July 25th, just get a reset form, then you're excused.
Thank you, Your Honor.
Judge Mack is not answering, been contacted.
Okay, all right, we're going to take care of that.
They might be around in the courthouse, I just don't have.
Okay.
Judge, I would like to say that it's not Miranda's fault that we haven't gotten an offer. She has to coordinate with other people and they haven't been helping her get this thing in order.
Oh, who do I need to subpoena to come down here? Do I need to
I
subpoena a
don't know, but
prosecutor?
she's been very gracious with me the whole time. I don't want it to look like I'm throwing her under the bus.
Oh,
It's
no.
not her.
I know you would never do that.
No, ma'am.
Sebastian De La Rosa.
Morning, Robert.
Norma. Yes, ma'am. Just see if Manny Rodriguez is available. He's over there. Manny, could you approach and speak with Ms. Ferguson?
Oh, yes.
And counsel you on this side. So where are we on CPS records? This is Sebastian De La Rosa, right?
Yes, Your Honor.
All right. So the issue we were here last time was for CPS records. So we were here in May. And I gave you all that amount of time to get the CPS records.
I'm told that there are no CPS records.
Okay, there are none. Okay.
That's what I'm told by the DA. There's a grand jury subpoena for CPS records, but I'm not finding any reference in my conversation from either Brittany or Travis that there are in fact any CPS records.
All right. Other than that, do you have all the discovery counsel?
I think so. We just got an offer today, Your Honor.
Okay.
So we'd ask you to give us some time to consider it. The other issue I have is we have a motion for bond reduction on file. Would you let us hear that?
All right, Ms. Ferguson, can you send them to Judge Nahara for a motion for a bond reduction?
Did you file a motion?
It's filed. It's on
Okay,
file.
well, we have to send a referral over to.
Thank you.
All right, and then can we do a plea deadline date on this case? Give me, how much time are you asking for a counsel? For him to think about it. How old are you?
20.
You're 20? All right, if you can give me 30 days for a plea deadline date.
August 8th.
All right, we'll be back on August 8th. On August 8th, you need to let the court know whether or not you're accepting the state's offer. You understand? Do you have any other questions? All right, thank you.
Thank you, Judge.
Norma, if you can give him a reset form for August 8th, because he may or may not be out of custody.
Thank you, Judge.
Oh, you're welcome. I still watch for you to see if you're posting
I
photos
do,
of flowers.
Do you take the thumbs up as being positive on this?
Yes,
Thumbs up,
yes,
like a positive thing.
yes. Atilano Carrillo. Who's the attorney for Atilano Carrillo?
That's Athena.
All right, I'm sorry, just have a seat. We'll get to you as soon. All right, come on down. Are you all ready?
Yes, sir.
Did you all confer with probation? Thank you. All right, the court is calling 2022 CR 5344, State of Texas versus Atilano Carrillo. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Valentina Cogut for Mr. Carrillo.
And are you Mr. Carrillo?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Your Honor, if I may, we
Yes.
were gonna ask for continuance for type of violation to be done in custody.
No. Because we were here on June 22nd, and this has been reset for July 6th. So we're going forward. Are y'all ready to go forward?
We could have a short, can we do it later this morning, Judge?
Sure.
Thanks, Judge. So,
Yes. Okay. Yes. Oh, sure. don't rush. I mean, if you have work at 1, you need to go have lunch. You shouldn't rush and, your food, as my mom would say, your food has to digest. Okay. Somebody is here on Jose Ramirez. Off docket matter? Yes. Morning. So where's your client?
He didn't bring it. Yeah, it was
okay.
a date for status on discovery.
Okay.
Okay, unfortunately, Judge, the CPS records were requested pre-indictment. And I followed up with the investigator who requested them pre-indictment twice. And they can't find them, so I'm gonna have to re-request them. I need to look into as well. So-
All right. So how much time are you all asking for?
I would say 30 days. I'll get I know that's being optimistic. Okay.
All right, Ms. Ferguson, can you give them a 30-day reset on Jose Ramirez?
I'm pretty sure, Your Honor, that if the AD needs to reach me before that, she will do. So,
Yes, we've been confirmed.
All right, we're going to come back August 8th.
thank you.
You're welcome.
Have a good day.
All right, thank you. You
Always a
too.
pleasure to be in this court.
Oh, thank you so much. And I'm going to send out a message. It is extremely hot in this court. Are they trying to burn us out? I'm close to just not having the robe on. Yeah. Okay. No, usually what ends up happening, CPS is a whole different separate entity. So usually they will automatically give records to the state, but sometimes they don't. And CPS records are confidential. So if the defense wants them, they have to file a subpoena. If the state has them, and they want to give a copy to the defense, I have to do an order so they can have a copy. And it has to be a protective order. You know, basically, they will not share those records with anybody. They're not going to duplicate them. Those usually don't come into evidence. Now, they're considered hearsay. Now, you can always bring in a caseworker and have the caseworker testify, but they won't be able to testify. For example, whoever reported that person to CPS, they won't be able to elicit testimony about that. Yeah, so they won't do that. Well, the reason why is because when you think about it, one, the law says that anybody who reports child abuse or whatever you're reporting for CPS, their identity is to remain secret. So if you, yes. And if you bring them into court, then I'm the one who called CPS. And so the CPS worker, when they receive a phone call saying there's child abuse or something issue with the child, the caseworker will go out and do their own investigation. So for example, if you were to call to report child abuse, you call the hotline and they say, okay, what's the name of the child and where is this? They'll try to get as much information as possible. Then they'll go out to the location where the child is supposedly located and they will do their own investigation. So they will come in. Now they will be able to testify. I received a phone call, you know, alleging child abuse and I went out and investigated. What did I do? But a lot of their records are confidential. Well, when I was a prosecutor, if there is some information that the CPS caseworker had that I wanted brought in, I would have them testify. But normally I see other prosecutors don't call the caseworker. Yeah. And then sometimes they may want to call the caseworker because maybe the caseworker did a video of talking to the defendant, because believe it or not, on the CPS side, one thing that makes it different from criminal law is if you are on the CPS side and you take the witness stand and you decide to invoke your right not to give testimony, they can hold that against you. So, yes, the person who's testifying now against the, say, for example, you're accused of child abuse. Yeah. So usually this ends up happening in cases that are involved sexual abuse of a child or injury to a child. So let's say you're charged with injury to a child and CPS takes custody of your child and you're trying to get your child back. Well, on the CPS side, they can call you as a witness and you'll have to testify. If you decide you're not going to testify, let's say they call you as a witness and they say, so did you hit your child on Tuesday? And you know you have a criminal case pending and you're under oath on the civil side. So you don't want to answer the question because you have a criminal case pending and it could be used against you. So you decide, I'm going to exercise my right not to testify. Well, on the civil side, that can be used against you. It can be assumed that you would have said yes if you would have testified. So a lot of times when I would have adult clients on the CPS side, there had to be choices made. Do you want to potentially not go to prison? Or do you want to testify on the CPS side? Because all the testimony on the CPS side, that can be used against you on the criminal side. But you'd be shocked the number of times people do not ask for CPS transcripts on that side, which they should, because usually defendants will testify on that side. Yes, I got it. All right, are the parties ready on Atlano Carrillo? All right, we're back on the record. And 2022 CR 5344, State of Texas versus Atlano Carrillo. Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Atlano Carrillo who was placed on deferred adjudication in 2022 CR 5344 for the offense of burglary of a building with intent to commit theft on August 25th, 2022 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 17th day of May, 2023 in Bexar County, Texas. The defendant Atlano Carrillo committed the offense of unauthorized use of a vehicle in violation of condition number 1.
How do you plead to that? True or not true?
True. And Judge, we waive and abandon the other violations alleged.
No objection.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there an agreement?
Judge, yes, ma'am. We've agreed with I've conferred with defense counsel. She's told me that the defendant has expressed an interest in getting inpatient drug treatment. And we have no objection to that if he wants to undergo a TAP evaluation and do whatever inpatient drug treatment that probation thinks is appropriate, Judge.
All right, so here's my question. And the violation of condition number 1, that's an unauthorized use. And then he's on probation for burglary with intent to commit theft. But there's restitution that's due to a place called Phantom Motors. Is Phantom Motors, is that vehicle related?
Yes, ma'am.
All right, is Phantom Motors a place where they sell vehicles?
Yes, ma'am.
All right, I don't see a reason to continue him because he's on probation for burglary of a building with intent to commit theft. And one of the cases that was taken in consideration was 2022 CR 5345. And then there was restitution to Phantom Motors, which is another vehicle place. And now we're back here for another vehicle. I don't understand that. And I do know for a fact that everybody who comes in this court, I ask, do you need anything? Is there anything else I can do to you so you can be successful? And this was a case where I wrote down that he was allowed to reside with his mother for 3 months because he was old enough to have his own place. And he was to do parenting classes. And what has he done other than pick up a new case? What have you done, sir, other than pick up a new charge?
No.
Nothing. He hasn't done anything. So I'm not inclined to continue him. I'm not going to continue him. I'm going to find him guilty. And I'm going to revoke him. Does anyone want to speak to the amount of time that's being requested? State, what are you requesting?
Judge, I believe the underlying is the 5 years. Is that,
No, he's
I'm sorry.
on 2.
Yes, ma'am. We'd ask for the 2 years, Judge, for the reasons that the court laid out. He really, he stopped reporting, I believe, a couple months after he was on probation, Judge. Hasn't done much while he's been on supervision, Judge.
All right, you want to say anything to the court?
No.
All right, defense.
Yes, Your Honor, we would ask the minimum, Your Honor, he has taken the responsibility for the first, new offense that he's picked up. It's his first NPR, for this case. He's admitted he has a drug issue. He was seeking, help and, was willing to go under, treatment for inpatient.
But was he seeking help after he picked up a new offense and got this motion to revoke? Or did he call his probation officer and said, oh, by the way, I need help with my drug issue. I have a drug issue.
Yes, Your Honor, we understand, but it's better late than never. I believe if he's continuing, and I know Your Honor revoked him, I believe if he's continued, he would be willing to pay the restitution owed to Phantom Motors. He would be able to go to inpatient treatment to address his drug issue that he has, and hopefully be successful, productive citizen.
All right. Anything you want to say?
No.
All right. I'm finding him guilty. I'm going to grant the motion. I'm going to sentence him to 20 months in the state jail facility. Given credit for any time served. There's to be probation. Was there ever a restitution amount given to you on Phantom Motors or Masood Vaziri?
No, Your Honor.
All right, there's no restitution that's been requested. Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it?
Okay.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand?
So,
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
so.
All right, good luck to you. You're gonna have to do better. Who's here on Gasper Rodriguez? Are you all ready? Yes. All right, have a good one. Okay. Oh, no, sure. Just let me know. Okay. Okay, awesome. Yes. All right, thank you. All right, on this case, Mr. Rodriguez, your attorney is taking a sabbatical. You're going to Europe. He didn't even have to tell us that. I think he just wanted us all to be jealous.
To be jealous.
Yeah, thank you. You see, right?
He could have left it just as sabbatical.
Yeah, he could have.
Imagine it.
He could have said, you know, I just need some me time, so I'm just taking a sabbatical. But no, I'm going to be in Europe for 2 months.
Cool.
A la Richard Garcia.
Yes, that's what we all learned from.
Yeah. All right. So this is your new attorney, Mr. Rodriguez.
Oh, manual. Hey.
So what I'm going to do is I am going to reset the cases so he'll have a chance to look over them and speak with you. and also for the state to have a chance to get the information that they want to get.
Do you know about the time period?
Well, this is what I'm going to do. I'm going to reset it for 30 days, but if the state has that information beforehand and your attorney wants it brought back beforehand, we'll be here.
Okay.
All right. Do you have any questions?
No, ma'am.
And your client told me that someone tried to take his food at the jail, so that's why he's in red, because there was a fight. I asked him if he wanted me to have the deputies inquire about that, but he said no. So if there's any issues at the jail, just let me know.
Will do, Judge.
All right. All right. What date, Ms. Ferguson? Okay. Let me give you a date. Caroline, the date she's been given, has it been August 8th?
Yeah, I was gonna ask you something.
All right, so we'll do August 8th. Is everyone okay with that?
Yes, Judge.
Yes, Judge.
Yes.
Okay, and I don't mean any disrespect by saying this because I think it's great. You remind me of Bruno from the cartoon.
Oh, Popeye.
No. You know, we don't talk about Bruno. You have that curly hair and everything. And honestly, I thought he was a great guy, so I don't care what anybody says. But I was just like, who does he remind me of? Yes, Encanto.
Yeah.
Do you get that a lot or no?
No, well, since I went into the jail, I've been getting like, when I take a shower, my hair falls down, like Jesus, look, but
Hey, that's okay.
yeah.
So tell me, with the hair thing at the jail, are they still just using shampoo that says shampoo on it, or they give you real shampoo?
No, you gotta buy the real shampoo on the commissary, but they give you little bars of soap. That's it.
Because last time I took my students to the Bear County Jail, I always tell them they just use regular soap and it just says soap.
Yeah, just regular soap. That's it.
I can say that because my brothers, when they were first starting out, I would say, what type of detergent are you using? They're like, it just says detergent. It's the cheap kind. That's what we can afford. So it's detergent.
Exactly.
All right, we'll see you back, Norma, on this one. Can we bring you back on August 8th? All right, so we'll see you back on August 8th. And if it needs to come back sooner, your attorney wants it sooner, we will do that.
Thank you, Judge.
All right, thank you. Thank you, Mr. Rodriguez.
You're welcome, Judge. What's your signal?
97 19 04.
I'll be setting up a video visit with you.
Okay, thank you.
Thank you.
All right, who's here on Fernando Espinoza Rodez? All right, come forward. All right, what's the update on the federal matter?
I don't know about any federal matter, Your Honor.
All right, you're on the wrong side, Mr. Leo. You've been in here a lot. You should know. All right, so,
Judge, I think this was connected to that case that we talked about earlier.
all right, and what date did we give that one? What's the name of the other one?
There are sadly a lot of ag kidnapping cases in this court, and I get all the defendants' names mixed up.
All right, let me see who it was. Norma, we gave,
Maybe
Yes.
that was August 3rd.
all right, we'll be back on August 3rd. Is there anything else?
No, Judge.
Any other day, Judge? I got a conflict.
Oh, yeah, August 3rd,
Any other day?
August 3rd.
August 3rd it is.
Yes, thank you. Fraulein Guzman. Fraulein Guzman. Oh, just have a seat. Your attorney's not here. Oh, there you go. All right, what's happening on this case? There was supposed to be a discovery. Defense attorney was supposed to provide the state with a hard drive. Did you do that?
Yes, I did, Judge. And I
When?
just received it. I
Okay.
haven't had time to review it, but I'm in the process.
All right, Ms. Ferguson. On this case, state, did you make an offer?
No, not yet. It's connected to that one with John Coons.
All right.
Unless I'm getting confused between the
No,
two
this
cases.
is a different you. This is Fraulein Guzman Velasquez.
Yeah, see, now you guys get what I'm talking about.
Okay.
On this one, again, we're still going through discovery. It's that entire box that's over there.
All right. We're going to put it at August 3rd. On August 3rd, states you need to be prepared to make an offer.
Yes, Judge.
All right, anything else?
No, Judge, thank you.
All right, thank you. Juan Carlos Soto Victorino.
Present for here.
All right, come forward, please. Where is he?
Believe he's in custody, Judge. I just walked in.
Oh, did you ask for him to be brought out?
I just walked in the door, Judge. I'm sorry.
All right. Damon Thomas.
Ready, Judge.
All right, come forward. All right, on this case, an offer is supposed to be due today.
We did make an offer, Judge.
Okay. All right, so I'm going to give you a plea deadline date. Ms. Ferguson? On Damon Thomas, I need a plea deadline date. How much time do you need, Mr. Thomas, to consider the offer?
Probably 4 weeks, Judge. But
Okay,
I'm going to be gone the end of July for about 2 weeks, so maybe into August.
all right, is he unable to talk?
Yes, Your Honor.
Okay, all right, so I'm asking you, how much time do you need to consider the state's offer? Your attorney's saying 4 weeks, is that enough time for you?
Yes, ma'am.
Okay. All right, Ms. Ferguson. On Damon Thomas, can we put it in 4 weeks' time? When are you going to be gone, counsel?
The last 2 weeks of July, so into August.
Okay,
And then Judge, initially, Charles Bunk represented him on a separate charge.
Mhm.
He worked out a deal, took a plea on that. Because of that, on this case, his bondsman got off the case since he was gonna go to TDC.
Mhm.
And so there's no bond set at this point, but that parole's about to come up, we believe. And so the state and I have agreed, or we have agreed to a bond amount.
oh, you all have to let Judge Nahara hear that one.
Okay.
Okay. All right, what date, Ms. Ferguson? Okay, August 7th, we'll be back for a plea deadline date. And counsel, if you'll get with Ms. Ferguson, if you file your motion, Judge Nahara will hear it right away.
Thank you, Judge.
All right, you're welcome. Is there anything else?
Nope, good.
Okay. Who's here on Villamille?
I'm present.
Okay, thank you. Okay, thanks. Court is calling 2023 CR 0543, State of Texas versus Wilbert Villamille. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jason Goss for Mr. Villamar.
And are you Mr. Villamille?
Yes.
Are you gonna have to speak up so I can hear?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Villamille, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on count 3 and waiving counts 1 and 2.
Any objections?
No, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of aggravated sexual assault of a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years in prison and life and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes,
Mr. Villamil, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, has your client had a chance to confer with an immigration attorney?
I have conferred with an immigration attorney. I have informed him that a plea to this is, he's actually a permanent resident. A plea to this would be a certain denial of future permanent residency and deportation after serving a prison sentence, which is what he's pleading to.
All right. Mr. Vial, did your counsel advise you of the consequences of pleading no contest or guilty in the application of federal immigration law?
What was that again? Sorry.
I said, did your attorney advise you of the consequences of entering a plea in this cause number, either no contest or
Yes.
guilty, and how that applies to federal immigration law?
Yes, Your Honor.
Did that advice include possible consequences such as deportation, exclusion from the United States, or the denial of naturalization?
Yes, Your Honor.
Do you understand the consequences of entering a plea in this case as it relates to your immigration status?
Yes, Your Honor.
All right. Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Sure.
According to the plea, you're pleading on count 3. Punishment is to be assessed at 15 years in the prison. There are no applications. There's to be no contact with the complainants, and there's Chapter 62 compliance. Did you understand?
Yes, Your Honor.
All right. Here's my question, because I see that affirmative finding of family violence has been crossed through. Is this complainant his relative or not?
Yes.
Okay.
Yes.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, sir.
State, is that the plea?
Yes.
Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions? No. Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
I know we offer states exhibit number 1 and all attachments.
Okay.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty. Court will find you guilty. Is there a reason I should accept this agreement? Why am I accepting this agreement?
Well, Your Honor, in this situation, what he has pled to is a single count of a single time of sexual assault of a child, which is aggravated sexual assault of a child. He has agreed to do this early on in his process. He is not contesting his guilt, and he is not contesting what's going on. He's agreed to go to prison, and 15 years is a substantial amount of time.
State, why should I accept
Your
this
Honor,
agreement?
Your Honor, the child is very young. She's in therapy right now. I discussed it with the mother. And this is, there is a desire to get closure early on in this case, Your Honor.
So
At this point, we haven't had to re-traumatize the child by bringing her in and talking to her about this case yet.
This case is horrible. And I mean, I know he says he's pleading to a one-time penetration, but from reading this,
He didn't say that. I said it because
Okay.
I was just talking about the legal
Yeah.
issues with that. So.
but I mean, having a child having her brother lick his butt.
That was something that I think was determined that did not happen.
Well, she says that he asked her to lick his butt.
That's a different one. Yes.
What is wrong with you?
Well, Your Honor, I'm not trying to like beat around the bush. She was showing me her crotch, and that's.
And you got turned on.
No, I didn't. I'm telling you, I'm not like physically like. Well, I did get turned on, but not. Well, after a while, she just kept doing that. Tell her not. You know what I mean? Like,
So you're blaming a 6-year-old?
I'm not blaming my
Your Honor,
6-year-old.
if I may, my client was sexually abused when he was a child.
How old is he now?
He's 35 years old now. But the trauma that he suffered as a child has definitely surfaced in a way that is abhorrent. It's in a way that is obviously it's not good. And that's why we are here. And he is willing to go to prison, be a lifetime registered sex offender, almost certainly be deported. He'll never live. He's been in this country since he was 2 years old. He will never live in this country again legally. And he will.
So
have to
he's
live
being released after he does his time, released to go somewhere else and deal with his trauma that may result in him molesting some other child?
Well, he has, what he is hoping to do is, as you know, the TDCJ system offers a pretty comprehensive sex offender counseling and treatment. And of course, you know, he will at some point be wanting to go on parole. He knows that he's going to have to complete that to do that. We have talked about it, explained it. He's going to take the opportunity to do that, as well as other programs that are offered in TDCJ. He is motivated to do that. And you know, at some point when he is released, as I said, he's going to go to a country that he has basically never lived in his entire life, which.
And what country would that be?
Mexico.
They have nice beaches there. So again, we go back to the point, what were you thinking?
Yeah. I can just say sorry, but like the only thing I can tell you is that I didn't like, I try not to hurt her. You know what I mean? Like,
Wait, are you saying that you were molesting her, and as you were molesting her, you were molesting her in such a way because you didn't want her to hurt her?
no, I asked her, you can put this in your mouth. That's it. And she said no. I said, that's fine. Okay, that's it.
No, this is a penetration.
Your Honor, if what he has pled to is, and what he confessed to is by penetrating the anus with his finger.
Mhm.
And he had told the police when they asked him that he told the police that he did that at the time, which is another thing. He was honest with the police. He told them what he did. You know, and at this point, we're asking for this because we have agreed early on not to leave this on a docket, not to go through the process, not to have his daughter have to come in. And as the prosecutor said, be traumatized by this, have to come in and talk to prosecutors, have to get the phone call from the DA's office. They want it done. They're going through a divorce. He's never going to have custody of these children. He's lost basically everything, including the country where he grew up. And he's going to lose his freedom for up to 15 years and for a minimum of 7.5. But as the court knows, parole doesn't happen like that for these cases. They're doing 75-85% of their time. And so he's lost his freedom for more than a decade. He has done a horrible thing, and there's nothing that he can say right now that can explain that. I think the court's questions of him, how he has confessed to you, and now that he has done it, and what
No, he pled no contest.
He pled no contest because I advised it because there's a civil case going on, but that's a legal advice that he was getting from his lawyer.
Yeah, so I mean, I understand, but he pled no contest. So again, we're back to what were you thinking? Because I'm trying to figure out where you're coming from to figure out whether I should follow this plea or not.
sorry, Your Honor, I didn't do it I didn't do it to like hurt my daughter. I tried, I'm begging and telling you, please, I'm telling you, please. I'm not trying to force my hand in her vagina or in her ass. I basically grabbed her and I put my finger where it shouldn't be. That's it. Like I can't, I don't know how to
No,
explain
so
it.
the way you're explaining it to me, you're making it seem like it was an accident.
No, it wasn't
So was it an accident or not? Because you're telling me you just grabbed her and you're making it seem like your finger just accidentally penetrated the
The
anus.
thing is, I just don't know what she wants. Like, she's spreading her legs at me. Like, what do you want me to do? And like, she's spreading her whole vagina at me, like at least 4 or 5 times. Dropping her pants, like literally, like it's not like I'm telling you like my actions were right.
I know, I'm just trying to figure out where you are mentally and yes.
So if I grab my daughter's butt and I throw her on the bed and I didn't like forcefully sleep.
Your Honor, at the time, he told police officers that he had put his finger inside of her anus.
So it wasn't accidental. Am I right in assuming that?
He did not tell the police officers it was accidental. I don't think that he's trying to communicate that to the court. We are asking the court to follow this plea bargain. It is obvious that the man has sexual deviancy. And it's obvious, but all of those things that we have for people who are charged and people who are convicted of this, all of those things we're doing here. He's going to the penitentiary. He's going to be a registered sex offender for the rest of his life. All of those things are what's happening in this situation for people who have this apparent or this abhorrent behavior. He's obviously injured this child and he understands that. He's signing for 15 years to go to prison because of what he's done.
All right, so this is a life case, honestly. So State, you want to explain to me why the court should follow this 15 years?
Your Honor, this was done, having been in this position, I have seen these cases that languish for 4, 5, 6 years. And I had discussion with the mother and the benefit of the child was to get this done, no right to appeal, so the child could move on. It's up to the court's discretion. I'm happy to reconfer with defense counsel as well on this.
All right, if you all want to reconfer, the court would be willing to accept a plea of 20 years, not 15. If you all want to reconfer on that, you can.
Okay.
All right.
Your Honor, 2 things. I'm set in jury trial in County Court 13. They're starting to pick the jury now.
Oh, tell them you're in felony court. I'll call County Court 13.
It's just Skinner. It's County Court 13 impact.
I'll call them. So if you all want to confer and see if he's willing to accept 20 years.
I can't talk to my client about something like this in the matter of a few minutes. I mean, this is something that we just asked for a reset. If that's what the court is asking us to do, it puts too much pressure on the attorney-client relationship for me to talk to him in the box about a complete reworking of this plea bargain. I spent hours with him in the jail, going over discovery, doing all this stuff, and this is I'm asking for a new setting.
All right, Ms. Ferguson, recall this for tomorrow.
And if I'm in jury trial.
Oh, tell 13, you need to be here tomorrow.
And have her jury wait.
Yes. This is district court. So I'll see you all tomorrow. Adias Hernandez Rivas. Adias Hernandez Rivas. Who's the attorney?
I'm covering Monica Guerrero.
All right, where is he?
I believe he's an inmate.
All right, did you all ask for him to be brought out?
Oh, I'm sorry. I thought I did. This Hernandez Rivas.
Christopher Lee Gonzalez. Who's the attorney for Christopher Lee Gonzalez? Just have a seat. Your attorney's not here.
Oh, Judge. He was supposed to hire an attorney.
Oh, come forward. Did you hire an attorney?
I'm in the middle of that.
No, you either have an attorney or you don't. Do you have an attorney?
Hopefully by Friday I will. I'm gonna go ahead and go with I think his name is Robert Mauer. So I talked to him today. I just gotta go and bring him some money Friday.
All right, Norman, see if Robert Maurer can come back here. Just have a seat.
Okay.
All right, who's here? Michael Johnston.
I am, Judge. We're ready.
All right. Court is calling 2023 CR 1649, State of Texas versus Michael Keith Johnston. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Richard Garcia for the defense. Ready, Judge?
Are you Mr. Johnston?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I did, Your Honor. Yes.
Court will find that the state is in compliance with discovery. Mr. Johnston, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am, I did.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Johnson, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney?
Yes,
Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with possession of a controlled substance penalty group 1 gram to 4 grams? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Fine.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I
Do
do.
you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Johnston, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine. State recommends deferred adjudication. There's $57 for drug testing. There's to be regular UAs, sober support meetings once a week. Did you understand that to be the plea?
Yes, ma'am.
Defense,
Yes, Your Honor.
state?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, I submit State's Exhibit 1 in the attachments.
No objections, Your Honor.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
And I'm sorry, state, you can continue to confer.
Thank you.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty. Court would defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor, we're asking that you waive the PSL.
Anything you wish to say on behalf of your client?
No, Your Honor, we just ask that you follow the plea bargain agreement.
All right, Mr. Johnson, when's the last time you had employment before being arrested?
It's been a while,
What's a while?
years.
Why are you not working?
Me and my grandmother we were having issues at the time, and she had my my paperwork.
How old are you?
Me, they're 29 going on 30.
Do you have any children?
No, ma'am.
So if you were released, do you have a place to stay?
Yes, ma'am.
Who would that be with?
My grandmother's house.
Does she want you there?
She's told me time and time to come back.
Okay.
He takes care of his grandmother, Judge.
Okay. All right, what's your drug of choice?
No, I prefer to use meth.
Okay, how often have you been using before being arrested?
Once or twice, about every week.
All right. How far did you go in school?
High school.
What are you planning on doing with the rest of your life?
Oh, first, plan on getting clean. I'm trying to get my shit together. But
Okay. You know, somebody told me a joke about that. They said they don't want it, and they don't have it.
right.
Just use that in your mind. The worst thing is to go up creek
Yeah.
and you know, my mom explained to me, she's like, if you're going up there without a paddle, that means you have to use your hands.
That's right.
So, all right. 4 years deferred adjudication, $57 restitution for drug testing. I'm going to want a referral to felony drug court. That's to be while in custody. If they don't accept him, then I'm going to want a TAP evaluation while in custody and to follow TAP recommendations. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. I'm going to want 90 sober meetings in 90 days upon release. 100 hours of community service restitution. Regular UAs. Well, regular random UAs. Field visits, 1 time per month for 3 months. And if everything is okay after that, then 1 time per month, every 3 months. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Oh, you have to go around, Richard.
No.
Did you review? It's an invisible wall there, right? Did you review that with that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, from here on out, we can go off the record. From here on out, everything that you do, you need to ask yourself, is this something that could result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. If you have an issue, communication in this court is key. Just let probation know. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge. Appreciate it. Thank you.
Sorry, what? Oh, okay. Okay, I'll get to that in a moment. Who's here on Chris? Oh, not that. Jose Romero. Court is calling 2023 CR 0652, State of Texas versus Jose Antonio Romero. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Manuel Rodriguez.
Are you Mr. Romero?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Romero, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, and you're proceeding with a repeater count?
Yes, Your Honor.
Okay. Mr. Romero, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it?
Yes.
All right, you're charged with the offense of criminal mischief, 2,500 to 30,000. Normally, that's a state jail felony with a range of punishment of 180 days up to 2 years in the state jail facility and a $10,000 fine. If the enhancement is proven to be true, then it will be a third-degree felony. So your range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine. Do you understand?
Yes.
If you have a plea bargain agreement with the state, the court doesn't have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Did you intend to give up those rights and enter into a plea bargain agreement?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Romero, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yeah.
According to the plea, punishment is to be assessed at 4 years in the prison. There are no applications. Did you understand that to be the plea? Defense?
Yes.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No.
Next, I'm showing you outside the agreement, you're not to have any contact with the YMCA at 2900 Ruiz. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Your Honor, I submit State's Exhibit 1 in the attachments.
We reviewed it, no objections, Judge.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Mr. Romero, with regards to the repeat offender enhancement allegations, how do you plead to those allegations? True or not true?
She's asking if those prior convictions that I showed you on my phone, if they're true or not true.
The true.
All right. The court will review State's Exhibits 1 and attachments. All right, can we go off the record for a moment? Okay, while that is happening, I have reviewed the record. Why did they ask you to get out of the pool at the YMCA? What's going on?
I have no idea, but I assume that it was for to get my things as a prize because people pick on me on the streets.
Okay. So if I follow this plea bargain agreement, what are you going to be doing with the rest of your life? Do you have people to stay with? What are you? your plans?
Rollerblading. Rollerblade. I get a government check.
Okay. All right. Oh, no problem. So any objections to the state reopening the case to produce more evidence, counsel?
None, Judge.
All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find both enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
My client's requesting all the credit for his time served, which I asked the clerk this morning, came out to 241 days credit in Bear County Jail. And we'd ask that you follow the plea bargain. Judge, thank you.
All right, thank you. All right, the court will follow your plea bargaining agreement. The court will sentence you to 4 years in the prison. Give you credit for any time served. Is there going to be restitution?
No, Judge, we reached out to the complaining witnesses in this case, and they were the ones that we were able to get a hold of were reimbursed through their insurance.
Okay. All right. There's to be no contact with YMCA at 2900 Ruiz. And as previously stated, the court is finding enhancements true. Is there anything else with regards to sentencing?
No, Your Honor.
No.
All right, did you review the document entitled trial court certification with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. We can go off the record. If there are some sort of issues, if there are mental health issues, if there are drug issues, there are plenty of places in San Antonio now that are free. You understand?
Yes.
All right, good luck to you. Thank you. All right, Manny, always good seeing you.
Always good to see you, Judge.
All right, who is Juan Soto Victorino? Norma, which date are we bringing this back on? It's Soto Victorino. This is all of the cases that the organized crime and the aggravated kidnapping. All right, we're going to be back on August 3rd.
Got it, Judge.
Thank you. Joseph Alexandra Castro. All right, on this one, an offer is due. So was an offer tendered or no?
Not currently.
Judge, not yet, is because I was promoted pretty recently. This wasn't my case before that, so I really haven't had a chance to look at this.
Okay, how much time are you asking for?
2 to 3 weeks, Judge, to have time to meet with some witnesses and to talk to the family.
All right, Ms. Ferguson. On this one, can you give them a 1-month reset, please? And if you all are off docket and come back sooner than that, you can just let Ms. Ferguson know.
Yes, sir. I would be excused.
You need to get a date.
Yes, sir.
All right, August 10th. Once you sign the reset form, you're excused.
Thank you, Your Honor.
You're welcome. Adias Hernandez Rivas. Come down. All right, you're standing in for Miss Guerrero. Where is she?
She's in Del Rio, Your Honor.
Okay. All right, when is she going to be back?
She's available tomorrow, but we haven't received an offer in Mr. Rivas's case.
Oh, well, first we need to see about discovery.
Oh, okay.
All right, Miss Ferguson, can you recall this case in 3 weeks? Yes. All right, August 3rd. It's Adias Hernandez Rivas. All right, that will be all. Thank you. All right, Norma, did we complete Soto, Rafael Soto? His attorney is Moreno.
Yes, sure.
Oh, okay. Have you all conferred with probation?
I haven't been able to discuss with probation yet, Your Honor, but I did have a chance to, but I did have a chance to review over the court summary and the motion with Mr. Soto, and I discussed it with Mr. Escobar. But if you need us to have a quick chat with
Oh,
probation, I can-
yes, probation is a part of this.
More than happy.
All right, thank you.
Thank you.
So Norma, I think this case is what we have left. Soto. Candace Cox. Oh, Norma, you're here for Wesley Crawford as well? All right. Has she asked for Wesley Crawford to come out? Where's Wesley Crawford? Oh, come forward. Could I see the file on Wesley Crawford? All right, why is this on the docket today? Because I show here that he's set for August 31st.
That I don't know, Judge.
All right, you're supposed to be here on August 31st, but we'll just put it for the same date, August 3rd. And on this case, has competency been restored? We don't know.
I believe it has, Judge.
Okay. Norma, just put it on August 3rd then. That's when it was previously set, but let's just put it for August 3rd. Because that's when her other case is set. All right, once you get a reset form, you're excused, okay?
Okay.
All right, thank you.
You, Judge.
You're welcome.
Judge, was it that Andy or the other client, was he also reset? I think it was.
The murder case, which one was it?
Adis Hernandez Rivas?
Yes, that's been reset.
Just double checking, Judge, again, yeah.
Oh, no problem.
Same day.
All right, who is here on Michael Herrera? All right, where is Michael Herrera?
He's right here.
All right, word to Dr. Jumas. All right, what's happening with Dr. Jumas?
I have no earthly idea. Dr. Jumas hasn't contacted me.
Have you seen the doctor yet?
Oh, man.
He usually will contact me. He has my cell and, lets me know kind of what's going on.
All right, let me text him.
Okay.
I'm tired.
Mhm.
All right, just give me a moment. I sent a text message to him so we can see if he's on it or not, so we can get it straightened out.
And just so the court, we've been watching the CAC videos in the case. That's what we've been doing this
Okay.
morning. So
All
we've
right.
been holed up back there.
Okay, no problem. Let me just see if he'll text me and then if he calls me back, I'll be able to have you all communicate with him so we can make sure we get this done. So just give us a few moments. Usually he responds very quickly to texts. Lazaro Espinoza Ramos. Hello. Hi, where's Lazarus?
I just realized he was recalled today. We didn't realize he was set today, but we're gonna bring a hard drive to get discovery. If you wanted to recall it one more time, so we could do that.
All right. Oh, this is the same case with all the others. Ms. Ferguson? On Lazaro Espinoza Ramos? He didn't show up for court today. He's in custody. He's in custody.
Okay, sorry about that.
That's okay. On this case, can you put it on the same date as the other cases? And that's the third, correct?
Yes, Judge.
Here, if you want, I can tell my contact. All right. And Deputy Laura, you can take him back unless you're bringing him out now. You can take him back. And let him know his attorney is in Del Rio. Rafael Soto. Are you all ready to proceed?
We already are.
All right, the court is calling 2018 CR 1720, State of Texas versus Rafael Anthony Soto. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Mario Moreno for defense.
And are you Mr. Soto?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Rafael Anthony Soto who was placed on community supervision for the offense of possession of a controlled substance, penalty group 1, less than 1 gram on June 8th, 2018 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
If I may, Your Honor, I had discussion with the state and with probation. At this time, defense is requesting if the court will allow for a short reset. The allegation in the case is a new number 1. DWI. The state is working on providing details of that DWI to defense so that we can prepare if a plea of true in this case is warranted. There's a potential resolution in the case if that is the route we're going to take, but defense would need time to review that new number 1 prior to advising Mr. Soto if a plea of true is required.
State.
Your Honor, the only violation in the MTR is the new number 1. So we would also ask for more time to evaluate the DWI.
All right, Ms. Ferguson, on this case, can you give me a reset date for 10 days, please?
Thank you, Judge.
Okay.
Thank you.
All right, July 20th. We'll see you back then. Just sign the reset form, then you're excused.
Thank you.
All right, thank you. All right, Christopher Gonzalez. Come forward.
Yes, Your Honor.
All right, Ms. Ferguson, on this case. Let me see.
That she was fine, but Sean, he wants it for a attorney now.
That's fine. I just need more time to come up with the money. So everybody wants 40 grand. So
I don't want to get in charge, I mean, in between you and your business
Yes, ma'am.
transaction.
I just need,
So who was the previous attorney on this?
I had,
It was Robert Vargas who was hired.
Okay. So, Norma called the MAC. You'll remain in the courtroom. Are you asking for a court-appointed attorney now?
yes, ma'am.
All right, Norma, if you'll contact MAC. Just have a seat.
Yes, ma'am.
All right. Norma, so we have Kenneth Baker, Lorraine Efron. Oh, okay. We've done Alexandra Castro, correct?
Give me 1 second, Judge. Max is an answer, Judge.
All right, let me call. Hi, we have someone here. Yes. It's 2000. CR 10364. And 2019 CR 12466.
The judge is strict on a case, Judge.
Well, they're telling me now it's just one case. I believe that's 2022 case. Okay, he's in the courtroom now. Do you want him to just remain here? All right, thank you. Bye-bye. All right, and then we've already done Alexandra Castro, have we? Number 8,
Yes.
okay. No, we haven't done that.
Yeah.
No. Okay. And then we have William Chomley. Oh, did you need something? I have your note and I'm constantly looking at it. Yes. Oh, sure. Take your time.
No, I mean, it's Friday, right? Yeah. Can you mute us?
All right, could I see the parties on the person who is waiting for an evaluation? That are on bond?
I'm not sure.
I think it's Arlene. Was
Is
it Arlene Gay?
Arlene Gay went?
Yes. All right, thank you. And then on Mr. Gonzalez, they're coming over with an attorney for you. Michael Herrera. That's Arlene, that's you with Arlene Gay, okay. Oh, come up, please. All right, Dr. Jim has texted me back and he says that he apologizes and that the interview hasn't been scheduled yet, but we're gonna get it scheduled. So what I'm gonna do is Norma, on this one, if you can give them a 30-day reset, and then we're gonna make sure that Dr. Jimis gets a chance to speak with you, okay?
Okay.
And Arlene, I'm going to give your number to Dr. Jimis, if you're okay with that.
He has it, but please give it again,
Okay.
in case.
August 15th. All right, we'll be back on August 15th. They'll give you a reset form and we'll make sure that you're able to get in touch with Dr. Jimis, okay? All right, do you have any questions about anything?
No, I don't.
All right, thank you.
Thank you.
And Arlene, if you would leave with Norma, your contact information and your client's contact information, and then that can be forwarded to Dr. Jimis.
Great.
And I'll see if he's in the system with an email address too. All right, what is happening with Mr. Yost? I see you're here.
Yes, Your Honor. I ran into Jason in the hall. He told me they've returned the money and they will not be representing him on withdrawal.
Oh,
So what you do about nothing, I suppose.
okay. All
But
right, then,
if
no,
Mr. Yost is here. I would love the opportunity to confer with Cornelius.
let me see where Mr. Cox is.
He's not in his office.
Yeah.
Super hot back there.
Nobody got to bring it right there today. They also need him next door. They're looking for him in different places.
I think it might be beneficial now that Mr. Yost, I know who his attorney is.
Oh, okay. Hey, can you stop by the 187 park and see where Mr. Yost? Well, the reason why he was set was when you hired an attorney, but my understanding, they returned the money. Okay, all right, thank you. Bye-bye. All right, Mr. Cox is on his way over.
Thank you, Your Honor.
You're welcome. Anybody else ready? Because want to wrap it up so everybody can go to lunch. Dominic Nicholson. Hello. So what is going on with this case?
We just need to discuss trial dates with the court.
All right. So has an offer been tendered?
Yes.
Was it tendered today or previously?
Well, we discussed it at our last setting.
Okay. All right. Do you want a jury trial?
Yes, ma'am.
State how long you expect this jury trial to last?
Depending, guilt, innocence, probably 3 or 4 days. Punishment, I haven't decided exactly what we're gonna do with punishment. It could be just a couple days. It could be 3 or 4 just for punishment.
3 or 4 days for punishment?
He does have a pending murder.
Ah,
Do in the other county.
okay, let me ask you this. If he were to be found guilty, and you never know what's going to happen at jury trial, would he be going to the court for punishment, or would he?
I honestly have not discussed that with him, but I would like to leave open that the jury would be.
Well, that would help us decide where to put you on the schedule. So, Ms. Ferguson, recall this case. I'm sorry.
He's saying jury.
The jury.
Okay. All right, Ms. Ferguson. Can you set this for jury trial? It's going to be 3 to 4 days. Total.
Well, not including punishment, you mean?
Oh, yeah. It's going to be 3 to 4 days unless they have
No, no.
videos that are 13 hours long.
Oh.
Yeah.
I don't know.
What
Not in the guilt innocence, but I'm not sure.
What time frame are we looking at?
Oh, she's going to give us a date.
Okay. Because I'm getting a little nervous about.
Well, we are not going to interfere with your competition because I want to see what happens.
Thank you. Thank you.
Yeah.
I'm
cheering you on.
I know. So appreciate it. I am sitting second chair on a capital murder that we're scheduled for July 31st.
Oh, you're not going to be in July.
Okay. And then October 3rd, I'm here.
Okay.
Yeah.
Everybody told me that Angelini said lunch is for wimps, but I don't feel that way. I see Pinkertons in our future. Today.
That's fine. I mean, we can make it work either way.
What do you mind if we confer with Norma a minute?
Oh, no. Oh, sir, you can have a seat. We're just getting a date.
Thank you, sir.
You're welcome. Cases and we can move you up sooner than that, we will, okay? All right, thank you.
No, that's gonna
Yes.
happen. That's
Yes.
gonna.
Your attorney, and I will tell you, sir, if there's some sort of video that needs to be seen and maybe there's something with the equipment and she can't do it at the jail, she can let the court know and we'll make accommodations. You're welcome.
Yeah, no, well, that's.
So who are we waiting on?
Mr. Rector's here, and then we're just on Dios. 20 days. And we're waiting on that.
Okay. All right. Mr. Gonzalez, come forward, please. Come forward. All right, your attorney is going to be Michael DeLeon. All right, Ms. Ferguson. Can we reset this for next week so we can make sure that Mr. DeLeon is available? All right, so you'll be back here on Monday and you'll get a chance to meet with your attorney.
Okay.
All right, Ms. Ferguson, we'll give you a reset form, then you're excused. You're welcome.
Have a good day.
Oh, thank you. You too. All right, so let me see who that leaves because we should be wrapping things up. I know we need to have another festival because this is just not going right. All right.
Judge, may we approach?
Yes. Who is it on?
Jose Sanchez, Your Honor.
All right, could I see the file on Jose Sanchez? And Mr. Sanchez, come on down.
Is he in the middle, Your Honor?
Yes. All right. Okay, what is happening here? We were here last time, so there's supposed to be a possible video of an interrogation of Mr. Sanchez.
Yes, Your Honor, we still believe there is. The Alamo Heights Police Department responded that he was not interrogated and that they did not say there's not a video. They said, we've given you all the video. He was not interrogated. The facts indicate to us that he in fact was interrogated and there are cameras in the interrogation cell. So that's where we're at. I plan to issue a subpoena.
Okay, so they're saying they don't have a video?
They're saying they didn't say that. They said we've given you all the video.
Yes, Your Honor. So I emailed AHPD and what the detective emailed me back is the only video available is what was uploaded. The suspect was never interrogated. What we'd like to do, if we could, is get a setting for like a plea deadline setting, Judge, and give the defense counsel rather, time to subpoena any video from Alamo Heights PD.
All right, so you believe a video is in existence?
I believe my client when he tells me, Judge, that he was interrogated because he gave me some specifics. And I know that there's video in that cell. And I would be very surprised if there's no video taken of him. That would be very unusual. So I do believe there was.
All right, Ms. Ferguson. On this case, give me a 3-week reset and that's your plea deadline date.
Okay. Judge, I'm going to subpoena those to the court on that day.
Okay. And have the officer come.
I am going to, Judge.
All right, thank
I'm going to
you.
have 2 of them there.
All right.
We may resolve the case in this. Okay.
August when? All right, August 7th.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Yes.
Just remove it. And I'll take it.
Yes.
There's actually a feature on my leash.
Okay. And he didn't show, did he? Okay.
Second row, second channel. All that stuff.
Here's this.
That's what's.
All right, Beecham is the person who has competency issues. And I believe they've already said he's not going to be restored. So on this one, set this for a month out. Yes. What date?
I like how he did that so quickly.
Yeah.
Like he did this, like, I'm just gonna do it. He called me.
All right. Then we have Candace Cox. Okay. All right, thank you. All right, and Dinah, if you want to go on lunch break, you can go ahead and go. I don't think, unless they planning on working something out. All right, the other one is Orlando Cuevas. Which page is this on? Okay. All right, we'll put it on Monday. Yeah.
No. You guys enjoy your lunch. Yes.
And then we have Estrada Perez. This is the case that should be coming back on August 3rd.
Oh, yeah, Miguel.
Yes.
You know, I don't have a window in my office. I keep getting notifications that screen. Oh, yeah, I got it.
Eric Gonzalez Lopez. Well, today was supposed to be for discovery. Who is his attorney? Ah,
He's part of that.
all right. Yes.
Yeah.
Judge.
All right, thank you. Okay. All right, enjoy. Where are you going to be?
My girlfriend's family wanted to go to South Padre.
Oh, look at you.
Oh, guys, I
wanted to go.
Thank you, Brittany. Not because I didn't know.
Okay.
I would rather.
We want you there.
They want me there.
Okay.
Yeah,
No, it's just,
we're showing you.
they scheduled it all last
Okay. All right. Well, enjoy. Don't get any sand fleas. All right. Who's here on Chris Lind?
That's Cornelius.
All right.
Marco Marino Vasquez. Bring that back on the 10th. Is he on the docket? Yeah, he is on the docket. It's David Garcia.
Oh, on the tenth, yes.
No problem. And then we have Dominique Nicholson.
That's what Lorraine.
All right, what date? Okay.
Ben was already sent back.
Okay, that's fine. And Patrick Sanchez, he's incompetent. So did he regain competency? And we'll recall that for the 10th as well. Mr. Cox.
Yes, ma'am.
Hi, you have Mr. Yost and you have Mr. Lind on the docket today.
So who?
Chris Lind. All right, so we will be actually,
I didn't get that notification.
all right, we're gonna make things happen. So actually, Norma, I think we'll be back on the 10th instead of tomorrow, but we shall see.
Say Chris Lynn.
LYND.